All persons having anything to do for the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Ditkoff. To my left is Judge Englander. And together we are your panel for the 6 cases we are hearing this morning. I should point out, by the way, that we are in the recently renamed Christopher Armstrong courtroom. And thank you all for the delayed start time, even if you didn't have a choice on the matter. It allowed us to welcome our newest colleague. I assume you're all familiar with the rules of our court in terms of 15 minutes per side, no opportunity for rebuttal. We have read the briefs, we're familiar with the facts and the arguments. Therefore, since 15 minutes is generally not a great deal of time, we would urge you to the extent possible to cut to the chase. That said, if you have said your piece, there is no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, we will call the first case, 2022 P89, Commonwealth versus ALVES. And we will hear first today from the Commonwealth.
Thank you, Your Honor. Good morning. Stacey Gauthier for the Commonwealth. It's the Commonwealth's, this is, I don't usually start on this side, I apologize. This is the Commonwealth's appeal of the defendant's motion to suppress that was denied by the judge. The Commonwealth's position that first, the judge erroneously found that there was no probable cause in the affidavit for the thermal imaging warrant for that to issue, and also it's our position that the judge erroneously found that the chief, the affiant, recklessly left out a self-serving statement made by the defendant 2 years prior to the investigation, and that even adding that back in would essentially negate the probable cause. So with regard to probable cause, it's the Commonwealth's position that there was probable cause for the thermal imaging warrant to issue. First, we have the smell of marijuana that could Yes.
Can we, in fact, cut to the chase?
Sure.
Let's assume, arguendo, that the combination of the odor of unburnt marijuana and the electricity usage established probable cause that marijuana was being grown in the barn. How do we get to probable cause that this was an illegal operation, given that everyone is allowed a certain amount that can be grown, and with registration or licensing, one can grow a lot more? How does the quantity or the absence of a license get established here?
Well, Your Honor, first, with regard to the licensing, I would suggest that there was an inference that the defendant was not licensed because, according to the electric company, who are the experts in the use of electrical usage in North Attleboro, they stated that the defendant's barn was using almost a commercial amount of electricity, and it was not zoned for commercial use. So I would suggest that that shows that he was not properly licensed because the statute requires
Where's the not zoned for commercial use in the affidavit? I didn't see that. I saw the all commercial rate of electricity use, but I didn't see the zoned.
I apologize, I don't have the site off the top of my head. So on page 50, Commonwealth's Record Appendix 51, Chief McQuaid had averred that it is highly unusual for a detached structure that is not zoned for commercial use to have an electric bill that is 15 to 20 times higher than the main residence.
And you think that's enough to infer that it
I would
wasn't
suggest that that's enough, yes. So that's why the Commonwealth,
It's enough to show that it's not a commercially licensed marijuana operation.
that's correct. So
What do you do with canning?
with the,
With the canning case, what do you do with the fact that
That it
there's
could
a
be
right-
personal?
The person could be licensed to grow marijuana for themselves medically?
so with regard to the personal use, I believe the statute is you're allowed to have up to 12 plants. And so I would suggest,
No, we're talking about medical marijuana. You're allowed 60 days of marijuana.
so I would suggest that goes to the extremely high usage, again, of electricity. The electricity that the defendant was using was so high that it blew a transformer.
How
And
would
so
you-
I would suggest
well,
that.
Putting
sorry.
aside whether or not we know that it was that blew the transformer, how do we know that the admittedly high electricity use here translates to more than 12 plants or whatever the number is?
Because of the fact that it blew the transformer, I would suggest that if the amount of power used to be growing what he was growing for personal use blows transformers, then wouldn't it make sense that transformers would be blowing all over town, because it's unlikely that this defendant's the only person that's growing a personal amount of marijuana. And electric,
Talking about two different things.
I'm sorry.
Okay, there are three different ways that you can grow marijuana legally in this Commonwealth. One, for personal use, up to 12 plants. Two, commercially, where you have to be licensed through the town. There's a very complicated process to do that. And three, for medical marijuana usage, up to 60 days use. How do we know that this person wasn't just growing for medical marijuana use? That's what canning is all about. This is why I don't understand how we're not talking about canning here.
because in Canning, it was a CI that went and told the police that the defendant was growing marijuana. Here, we have the electric company. They're the experts, I would suggest, in electrical usage in the town of North Attleboro, and they are this is an anomaly to them. They're surprised that the defendant is growing using this much electricity. So they go to the police and they report to the police that they're suspicious of this. And I would suggest that as the experts in the North Attleboro use of electrical, that if this was not an anomaly to them, that they wouldn't have reported this to the police. And if it was, I imagine that he's not the only person growing medical marijuana in the town of North Attleboro.
But why
But this
isn't
is so high that it's an anomaly.
Counsel, why isn't that piling inference on inference? That they had flagged the amount of usage of electricity, but whether that translates to 12 plants or 24 plants, we have no idea, do we?
We know that it's of such great amount that it's causing concern with the electrical company, and that it's possibly, they didn't have any other explanation for it, blowing transformers. And they're so concerned that they go to the police. And then on top of that, we have the defendant who's paying his electric bills occasionally in cash, according to one of the emails between the electric company on Commonwealth's Record Appendix at page 71.
And help me with how the payment in cash provides an additional inference that the operation is illegal.
I believe that, and Chief McQuaid had averred in his affidavit that, or maybe it was at the hearing on the Franks motion, that it's drug dealers sometimes use paying cash. They put houses in other people's names.
So that's
that's-
an inference that by paying in cash, that's an inference that he's engaged in an illegal drug trade as opposed to someone who needs some marijuana medically and is properly licensed to grow it.
It could be. I mean, it's one
Well,
factor.
could be. I mean, it's a low bar. Low is probably not the right word, but it's a less than 50% thing we're talking about, probable cause. But
That's correct.
guesses or could-bes, I'm not sure really meet the standard, right?
Well, when you combine everything, I mean, the police don't have to exclude every other possibility in order to find probable cause, because it is a low bar. It's just, I mean, the magistrate needs to have a substantial basis for concluding that the items of the crime are probably in the place to be searched.
But to the extent you're citing to things in the Commonwealth's favor that came out at the Franks hearing, we can't do that, can we? Doesn't it have to be?
It's in the four corners. It's in the four corners of the affidavit.
It is. So it didn't come out from the Franks hearing.
I can't, I thought that he had averred in the affidavit that drug dealers sometimes use drugs. I think he also said that sometimes they put houses, in other people's names, or sometimes they store things in, like unattached garages. I just don't have a site right at the second, but I thought that he had put it in the affidavit.
Unless my colleagues have a specific question on this, can I switch gears a little bit and ask, you emphasize in the brief the context here, namely that this was not a search of a residence and it was a minimally intrusive search in terms of the flyover and the imaging of the heat signature. How are you suggesting that changes the probable cause analysis, if at all? I know there are cases that say that the constitutional protections are at their zenith when you're talking about an intrusive search of a home, but I have yet to find a case that says you don't need the same probable cause if it's not a home.
No, I don't have a case. I believe it's the same probable cause. It doesn't change. I don't have a case that says that it changes for, an outside thermal imaging.
So how is it relevant, if at all, that this is not a residence and it was a minimally invasive search? Or it could be characterized as that.
I don't think that it changes it at all. I'm sorry, I don't recall where I wrote that specific quote in my brief, and I didn't see it. in
You didn't have
section.
that specific quote. I'm paraphrasing.
It's something that jumps out, though, isn't it? I mean, the search here was a minimally intrusive search done to be minimally intrusive, and yet we're applying exactly the same probable cause standard. If there was probable cause, if we assume that the searches are of the same magnitude in the law, then they didn't need to do a thermal search. They simply could have gotten a warrant to enter the barn.
But
I think the question Judge Milkey's asking is there some difference because the search is minimally intrusive? Your answer is probably not.
Probably not, although it did add, it added certainly to going in, the second search to actually going into the house. They asked for the minimally invasive search first, and then use that information to get the second warrant.
It's so odd, though, I mean, this is neither here nor there, but that the police don't bother to actually find out how much energy it takes to do 12 plants, but they do get a helicopter to fly over. I mean, it's such a weird combination of under-policing and over-policing. Not your problem, obviously. The DA's office didn't get it until long after that, but that also jumps out.
Yeah, I mean.
And
I guess
along the lines of under-policing, how hard is it to have found out by checking with the Cannabis Control Commission whether this person was licensed to grow medical marijuana and put it in the affidavit?
It is correct, Your Honor, but obviously I'm here with what I have, so we look at what they did do, not what they didn't do.
Maybe someone really wanted to ride in a helicopter.
Yes. And just moving on to the second issue, if nobody has any more questions.
Just
on
one very specific
Yes.
question. Is there anything in the record that establishes how far away the driveway to the fishery is from the barn?
So not in the four corners of the affidavit. It was just adjacent. There was at the hearing, but not in the four corners of the
At the
affidavit.
hearing, he said he was within 50 feet, perhaps less.
Yes, that's correct. In the warrant, it was just adjacent.
You were getting to your second.
Yes, I know, I'm running low on time. So I would also say, Your Honors, that the judge erred in finding that Chief McQuaid was reckless in not putting the defendant's self-serving statement 2 years prior into the warrant. You know, the police don't need to rule out a suspect's innocent explanations when they seek a warrant for probable cause. But even adding that in, it doesn't undercut.
As I understand it, you're not challenging the Franks ruling as such. You're saying
Correct.
it doesn't matter.
Yes, yes, correct. Even putting that statement back in there, you know, welding doesn't smell like marijuana, so the police still know that there's marijuana cultivation going on in there. And I would suggest it just wouldn't make sense that this guy is renting out his, you know, garage where he grows his, you know, either medical or personal marijuana, and then risks somebody going in there from the welding company and
You might
stealing
have a
it.
fire, for example.
Yeah, true. And if there's no further questions, I'll rest in my brief.
Hearing none, thank you very much.
Thank
We'll
you.
hear from the defendant.
Thank you.
Thank you, Your Honors. Ken Van Colen for Mr. Alves. Down on the South Coast, we pronounce it Alves. To get right to the point, one of the things that's jumped out over and over again between the briefs and then the oral arguments and in I was the attorney that handled it in the motion to suppress, is the term self-serving statement. I'd like to point out that that so-called self-serving statement, there is no evidence presented that at the time Mr. Alves was talking with a representative of the electric company that he said, I have a construction or welding company leasing the property, I expected a higher bill. There's no evidence that that wasn't true at the time. Now, we know from the search
But that is exactly your problem, it seems to me, because it's 2.5 years before, and the affidavit itself indicates that as of January of 2017, he may well not have been engaged in a marijuana operation because his electricity was about a quarter of what it was 2 years later, maybe less.
But nonetheless, the word self-serving is very distracting.
I don't disagree with you
it's
about
distracting.
self-serving, right? I mean, self-serving doesn't make any sense in this context. He's simply saying something 2.5 years earlier.
Correct.
It
And
may even have been something that should have been disclosed, right?
And you
Because
couple-
it's
you
potentially
couple-
exculpatory.
you couple that with the idea that when the prosecution says that it was the high electrical usage that Schiffman went to the police department, it wasn't the high electrical usage. It was high, when the transformer blew or whatever happened, he sent workers there, the workers went there, they looked at it, it's right next to the fishery. They went to the adjacent property, which is 35 Indian Trail Road, and they detected an odor of marijuana, and they saw surveillance cameras and saw signs, and they said, you know what, we don't want to walk on the property, and they went back, and they reported to Schiffman a more global thing than a high electrical usage, and then that's what triggered this response to the police department, which is very important to this discussion, because when the police department then asks for all the information, they get this statement. And the problem here is, and I allude to the minimally invasive intrusion, it's minimally invasive for them to say, hey, let's go check out the property and we'll go and watch the traffic. Let's go see. Let's go knock on the door and see if there is.
That's not invasive. As a matter of law, that is not invasive. They can stand on it. They can stand where public can stand. They can smell what they can smell. That's not invasive.
Correct. And they
Okay.
could have.
So I don't understand the point.
He's agreeing with you.
I'm agreeing with you. It took almost zero effort for them to go and verify or not verify. But instead of doing that, this, at the time of the hearing, acting chief says he forgot to put it in during the hearing. When we've already been allowed the Franks hearing, and the DA is not contesting that, It's a significant piece of information that should have followed up with a little bit more investigation. Now, it just so happens that the welding equipment for high electrical usage is in prior case law. I think it's Alaska versus Cluss. I'm not positive, but I think that's the case. And it's been identified as a legitimate use for high electricity. And they have it in their information. But that's the piece of information they left out and didn't follow up on. Not only did they not do that, they don't have informants. They don't have drug sales. They don't have high foot traffic. They have nothing out of the ordinary that are all these plus factors, if you will, from Long, and also were included in Canning in like cases. This is a detective, at the time detective, then chief.
This seems to me to be an argument that there wasn't enough information to determine that there was a marijuana growing operation existing. And I find that extremely difficult to believe. There's huge electrical use. It spikes between 2017 and 2019, and they can smell it 50 feet away. I think the argument that obviously this panel is dealing with is less, is there a marijuana growing operation, and more, was it an illegal marijuana growing operation, right? And that argument was made below by you.
I'm not conceding the lack of probable cause. I'm not conceding there was probable cause. I suggest right from the get-go, there wasn't probable cause for that first search warrant. The information there about whether or not, well, they have to have not just a
So you don't think
illegal
it's
grow.
enough, you don't think it's probable cause to know that there's a huge spike in electrical usage over the course of 2 years, that the barn smells like marijuana from 50 feet away, it's all boarded up, and there's a surveillance camera outside?
Well, one piece at a time. I'd suggest that a high electrical usage in this affidavit is apples to oranges. It's a high electrical usage for an outbuilding. It's an outbuilding with electrical usage. He doesn't compare it to any other outbuilding in Attleboro. No one from the so-called experts from the electric company don't compare it to other outbuildings. They don't compare it to other barns, any other facilities. He just says residences use this much. And this barn or outbuilding uses way more. It's an apples to oranges.
Well, but for purposes of probable cause, which is not more likely than not, can't they accept the fact that the electrical company itself thought that this was an extraordinary event? The electrical company comes to them and says, this is really unusual, it looks like commercial use to us, that's what the amount of electricity is that they're using. Isn't that enough to believe that that's unusual?
I'm not necessarily agreeing the electrical company went with the electrical usage. This did not trigger until the employees checked out the transformer. Then there was other factors that went into it for them to reach out to the police department. The electric company, I suggest, and I don't know this, and it's not in any pleadings, but I suggest they can at any time say, you have a high electrical usage, we want to put you on a commercial rate. They don't need the police to do that. They don't need the police to check on that. I think they can just say, this is odd. If they thought it was odd, they could have just done their own inquiry into, or called them on the phone and say, you're using a lot of electricity, we should put you on a commercial rate. And
It was until they smell marijuana that they get concerned.
But
You can't separate out one fact from the other. We get all the facts when we determine probable cause.
I understand. However, when you look at a case like Overmeyer, where this court specifically said you cannot tell from an odor, no human being can tell from the odor whether there's 12 plants, 13 plants, 60 plants. They can't tell. So a high electrical usage and an odor of unburnt marijuana, I suggest, doesn't make probable cause. We don't even get there. And then when you add the omission, it reduces it.
The police chief says, I have, I've been doing this for 20 years. I have lots of training in narcotics. I've spoken to people about this, and I don't believe that with these electrical usages that this guy's growing 12 plants. Probable cause?
Well, that's not this case. In this
That
case,
is this case. I think I've paraphrased exactly what he says in his affidavit.
he doesn't have training. I agree, but we have
He
the
says he
benefit-
has training.
We have the benefit of the Franks hearing, and I don't think I'm I'm not sure what the right word is, but we have the benefit of the Franks hearing. We have the benefit of the
Is there a
cross-examination.
finding in the Franks hearing that he doesn't have sufficient training to make the statements that I just said?
It's in the memorandum, and it's in the transcripts. On the cross-examination as to his training, he doesn't really have any training.
But he can
says
speak to other people in law enforcement who can explain these things to him, can't he? I mean, can't that be part of how he makes his decisions? And he says in his affidavit, I've spoken to other people in law enforcement on these issues.
But they're not the ones it's a doctor can talk to another doctor, but that doctor shouldn't be making the doctor that never sees the patient shouldn't be making the diagnosis. The magistrate believes that he says he has all this training. In fact, he doesn't. Now, that wasn't part of the Franks in the sense that I'm not suggesting that he deliberately misled the clerk magistrate on his training, but he didn't have the training. I stepped through all the resources for training for narcotics investigations that we have in this part of Massachusetts, and he didn't attend any of that. And he had one, I think, I may be mistaken, one prior experience with a flare. I can't remember if he did or not, but he didn't know anything about the flare, didn't know how it worked. He just knew what the result of the flare was.
He says, I have training and I've spoken to people, and based on that, in the affidavit, based on that, I don't believe that this was 12 plants. I believe it's more than 12 plants. There's no finding in the Franks hearing that he doesn't have sufficient training to reach that conclusion, right?
There is no finding. No judge.
Nor did you ask the judge on that. I mean, your argument with the judge had to do with his not putting in the January note, but you didn't say to the judge, look, all this stuff about inferring the amount. We're talking right now about inferring the amount based on what the evidence was. You didn't argue to the judge that they didn't have a basis to infer the amount?
I did not at that hearing.
And you elicited he has annual in-training or service training with the state and had training on the issue of detection of marijuana through odor. I mean, you elicited that.
At the academy in 1999, I think he said.
He said several years ago. Is that 99?
I believe I followed up. He hadn't had any recent training with that. Was a line of questioning along that? No.
Your argument, I take it, is that it's not enough to include a conclusory statement about the amount. There has to be specific articulable facts in the affidavit that establishes probable cause with regard to the amount.
Yes. Any other questions?
I'm good.
I think we're good on our end.
Thank you. Just a summation, I think there wasn't probable cause in the first place. I think the missing statement reduces probable cause, and then the judge, in his own, Judge Mathers, switched gears, said even in canning, they don't have the requirements pursuant to canning as well. So I suggest that the judge's ruling should be affirmed. Thank you.
Thank you very much. The case is submitted.
Thank you.
Our second case of the day is 2021 P856, Commonwealth v. CHOUTE. And my apologies if I have mispronounced the defendant's name as I did in the first case.
Good morning, Your Honors. May it please the Court, Chetan Tiwari for Appellant J. CHOUTE.
Could you just tilt the microphone? You don't need to be close, but it needs to be directionally correct.
Is this better?
Yes.
Yeah. All right. Thank you, Your Honor. May it please the Court, Chetan Tiwari for Appellant J. CHOUTE. So, under the American Constitution, everybody has a right to a fair trial. Mr. CHOUTE did not receive that. The first example is the admission of the prejudicial evidence of the drug paraphernalia that was in the lockbox. This was admitted over objection, over motion in limine to exclude it, and it was evidence of a charge that was uncharged. It was, I don't want to even say minimally relevant to the charge.
Why isn't it evidence that he knows the gun is loaded?
Pardon me, Your Honor?
Why isn't it evidence that he knows the gun is loaded?
That he knows the gun
Is loaded. He's got a gun. The Commonwealth has to prove that he knows it's loaded. Why isn't drug dealing evidence that he knows it's loaded?
Your Honor, so the issue there is that for that connection to be made, there must be some connection between Mr. CHOUTE and the evidence of the drug paraphernalia. It's a circular argument where it's effectively asking the jury to assume guilt that he knows of this evidence of the drug paraphernalia, therefore he'll know of the gun and that the gun is loaded.
It's funny. I think it is a little bit of a circular argument, but I'm not sure where the circle starts. If you assume that there was sufficient evidence of constructive possession of the entire contents of the bag, then why doesn't it then become relevant that he was, or that the bag indicated evidence of drug distribution, therefore knowledge that the gun in that bag was loaded? I think that's the Commonwealth's argument.
Do you mind asking that one more time, Your Honor? Just so I understand it clearly.
I'm not sure I'm asking anything differently than what Judge Ditkoff asked. Your response to his argument, why isn't it evidence of knowledge, is first you have to show that my client possessed it, right? Mm-hmm. That was your response. And my point is, well, if you assume that they've shown enough for constructive possession, then doesn't it become relevant to the issue of knowledge?
Knowledge of the loaded, not of possession of the gun, not knowledge of the gun, but knowledge that the gun has bullets in it.
So, Your Honor, the fact that it was loaded was no longer charged. The fact that it was a loaded gun, I believe that was taken off.
He was convicted of carrying a loaded firearm and given a 6 months consecutive sentence.
So, sorry, Your Honor, I must have confused. I thought it was just possession of the firearm. I didn't realize that. I apologize for that. But
the prosecutor had been argued in closing that a drug dealer would have a loaded gun because an unloaded gun is a useless gun.
So the issue with, again, just going back to that, if there was sufficient evidence for knowledge of the firearm, then the evidence of the drug paraphernalia becomes cumulative and, quite frankly, unnecessary and just simply prejudicial. It's just creating a boogeyman.
Why is it cumulative? Why isn't that a good argument that if you're a drug dealer who's using the gun to protect your drug deal, you'd know whether it was loaded or not?
I think, again, it has to go back to there has to be evidence that he is a drug dealer. And if there is sufficient evidence of knowledge of the gun, there still isn't sufficient evidence knowledge that there's distribution going on. And that's probably part of the reason why he wasn't charged with that charge, because there wasn't sufficient evidence for a distribution charge. That charge was null-prossed well before trial. And if there was sufficient evidence of the distribution and the gun, he would have been charged for both.
Right, but can't the prosecution make the following? Can't the prosecution decide as follows? There's only traces of cocaine, okay? We don't have enough to get a jury to find beyond a reasonable doubt he's engaged in distribution. But we can still put in the evidence to the extent it's probative on whether he knew that the gun was loaded.
And I think this is where we get into the balancing act, the balancing decision that didn't happen, right? It's, even if it is minimally relevant, it has to be sufficiently probative. And here, it wasn't. And we have nothing from the lower court to say that it was. The lower court's decision was, if what the Commonwealth is soliciting is related to their case and relevant and not overly prejudicial, they can ask, and that's what I've found.
So what's your best case on the, you cited a case, I think, that sort of says, look, we have to see that the judge did, in fact, do the balancing under 403, right? What's your best case on that? So
the two cases I cited, one showing where it doesn't meet the mark was Little, and the one exemplifying how an instruction does meet the mark is Helfand. In Little, the judge effectively gave short shrift to the balancing decision And the appellate court stated, the SJC stated that this is insufficient. And in Health Fountain's quoting, they said that the judge took a careful and conservative approach to the evidence and therefore did a proper balancing act and showed why it wasn't overly prejudicial. And those are probably the two cases that I would rely on for how the balancing needs to be done at the lower court.
So Little is a case where there's a reversal? You didn't show us you were balancing?
That's correct. It basically showed that the balancing act wasn't done properly at the trial. Is there a follow-up, or should I continue?
I'm reading Little. Go ahead.
Was that the shooting, Little? Was
Pardon
that the shooting, Little?
I can give you this.
It's not important. Judge Englander will know soon enough.
It's cited on page 40 of.
Assuming I read faster than I do.
We'll know eventually, anyhow.
It's cited on page 39 and 40 of my brief, to give you the exact citation. And then there's the fact that there's a dearth of evidence in this case of knowledge. The gun was not in plain view. There was no consciousness of guilt. Mr. Chute did not demonstrate any consciousness of guilt when he was interacting with the police. And there was no evidence of connecting Mr. Chute to the contraband, no pager, no rolls of bills, no ledger. And there was no evidence that the firearm was recently used. So effectively, the Commonwealth was shoehorning in this extra information, this extra evidence to try to create this boogeyman of a drug dealer in front of the jury. And again, drug distribution and accusations of Mr. Chute being a drug dealer, that was never on the table. That wasn't part of the case. But due to the dearth of evidence, the Commonwealth moved forward with it. Now, just going back to
on this issue, was there a limiting instruction requested and given as to the drug distribution evidence?
There was a limiting instruction requested. It was given at the end of the trial. It wasn't given as the evidence came in. And sorry, one thing I did want to mention, some of the evidence of the drug distribution was Sergeant Hurton's testimony as an expert stating that, drug dealers have guns. And that's just wholly inappropriate, again, considering that drug distribution was not a charge on the table. And coming from a police officer who has the credibility effectively assigned from a jury, that makes it even more difficult to put up a defense. And the limiting instruction, which wasn't given at the time this evidence came in, it was not a very particular instruction. It simply stated that, charges on the table are what you need to consider. Don't consider charges for anything else, or, and effectively gave some examples of propensity reasoning, but it wasn't a very forceful, timely limiting instruction, which reduced the effect of it. And then getting into the probative value. So the Commonwealth argue so getting to probative value. So there's Hawley and Gibson, which are the two cases that the Commonwealth rely on. And in Hawley, there's direct evidence of connection to the firearm. And effectively, the Commonwealth is arguing that knowledge and motive, the evidence of drug distribution can go to knowledge and motive of possession of the firearm. In the sites that the Commonwealth provide, the reasoning is a little bit stronger because in Hawley, it was a murder case, and the evidence of drug distribution came into the motive for the murder. They're saying that in that case, it was that the motive for the murder was because the defendant had lost a source of income. So there was a direct connection there, and that also had to go. There was also evidence that the reason that evidence of the firearm the reason that the evidence of the drug distribution came in was to support, again, just the reason for the crime as it happened. With Gibson, there was talk about theft of firearms. That was uncharged conduct. But again, there was text messages connecting the theft of the guns to the actual crime. So there is a connection in both those cases, there's a connection to the uncharged conduct directly to the crime that has been charged. Here, that connection doesn't
Counselor,
exist.
if I can bring up something else. Your friend indicated in his letter that you object to our receiving Exhibit 1 from the suppression hearing. Could you tell us why?
I wasn't objecting to Exhibit 1, and I did want to respond to that after the hearing. The dispatcher called to Sergeant Hurton. We have no objection to that, and that was Exhibit 1. That was marked as Exhibit 1 in the suppression hearing. The 911 call was not marked as Exhibit 1. It just happened to be on the same CD. So there's some confusion there as to whether it was actually admitted or not. And the 911 call is not something that Sergeant Hurton had heard or had information of. Actually, the information is quite different. The 911 call, the alleged victim states, the gun may be unlicensed, I don't know. Paraphrasing.
So do I understand you correctly to be saying that the jury had the 911 call even though it may not have been admitted in evidence?
The jury did not get the 911 call was only at the suppression hearing.
We're talking about the suppression hearing evidence. So did the judge have the 911 call?
The judge did have the 911.
I'm sorry, I didn't mean the jury, I meant the
And
judge.
was there an objection at the time to the judge having the 911 call?
There was.
On what basis?
It was a bit, couldn't be
Oh,
authentic.
because the officer never heard it?
That's correct.
And that objection was made specifically?
That's correct, Your Honor.
Okay.
And so Sergeant Hurton at the time, that information that this gun may or may not be licensed, that was never conveyed to him in the dispatcher call. The dispatcher just says, there's a gun.
But did the dispatcher I apologize, I have not been able to listen to this, but did the dispatcher give the information that he had threatened the person who called in?
Yes, I believe,
So there were, what was heard through dispatch is, he took the tablet, threatened the victim, and had a gun
may have a gun, yes,
in a lockbox.
in a lockbox. And there was no connection of threatening with the gun. There was no connection of the gun with the crime. It was effectively, in effect, it was, he may have a gun, he threatened us, and he took a tablet.
Okay.
I'll just quickly move on. That's a good segue into the suppression argument in the short amount of time that I have. So probable cause, and Your Honor, you put it quite well in the prior argument. Probable cause is more than could be or guesses. That's not the standard for probable cause, and that's effectively what is all that the Commonwealth had before searching the rest of the car after it had already acquired the tablet. It had probable cause to look for the tablet. It almost immediately found the tablet, and that's where the search should have ended. But the Commonwealth then, the officer, Sergeant Hurton, then went on and continued to search the vehicle.
Why isn't the gun evidence of the theft? The victim informs the police that she's threatened by someone who has displayed a gun to her. So why doesn't the gun support the victim's story and the evidence of theft?
So there's two reasons for that, Your Honor. The first is the gun was never connected to a threat. It was, he threatened us, he took a tablet.
Right, but if you show someone a gun and then you threaten them, I don't think it's a huge leap to say that the gun makes the threat more credible.
If it was put that way, you're absolutely correct, Your Honor, but it wasn't. It was, he has a gun that's in a lockbox. We saw it the night before.
Yeah, he displayed a gun to me and then he makes a threat and takes my tablet. Why isn't that gun evidence there?
So, and I'm obviously not trying to be difficult, but I think the difference here is in the 911 call, which at this point Sergeant Hurton has no knowledge of, is she states that I saw the gun the night before. So the gun it's something that he may or may not have, and she acquired knowledge of it at some point, but the connection between the gun and the threat is very tenuous at best.
So you say because at that point they've found the tablet and they have no further probable cause, you're assuming, by the way, that the information that came in on the 911 call is not available to us, which is actually an issue before the SJC right now. But because of that, they can't search the car anymore.
That's correct, and the
What about for evidence that might have been relevant to the taking of the tablet? I mean, it's a car, you don't need a warrant, You know that you have now probable cause that some crime has been committed, right? Why can't you search the rest of the car for that crime?
He had admitted to taking the tablet and saying that he was going to return it at that.
That doesn't, well, okay, all right.
And on top of that, just really quickly.
Okay, Councilor.
I do have one more question, unfortunately, on another issue, but it's pretty specific. One of the parts of the closing you object to is where the prosecutor directs the attention to the video and says, does that look like a person who's not digging through a backpack? How can we possibly determine whether that's supported without seeing the video?
The testimony, I believe, is quite clear that, in my mind, that the testimony was quite clear where Sergeant Hurton states that he wasn't close to
That's what he saw, but there's a video that the prosecutor is describing, and you say he's describing it inaccurately. Well, how do we do that without seeing the video? How do we determine that?
I'm happy to file a motion to expand the record to include the video.
You don't have to expand, you just have to get a copy of it to us.
I'll make sure that you get that.
I mean, it's part of the record, it's an exhibit, right, below, so just,
Okay, I'll make sure.
I think we need to see it.
Okay. I'm out of time, so unless you have any other questions, I'll wrap up.
Thank you very much, Counsel. We will hear from the Commonwealth.
Good morning. May it please the Court. Pavan Nagavelli, Assistant District Attorney for the Commonwealth. I was also the trial prosecutor on this matter. The first issue before the Court is whether or not...
Not the suppression hearing, right?
What was that?
But not the suppression hearing, right?
Yes, Your Honor. Not the motion to suppress hearing, but the trial of the jury trial of this matter. The first issue before the Court in regards to the motion to suppress, I would ask that the Court find that the trial court, the motion judge did in fact properly deny that motion because the officers did have probable cause to believe that a crime had occurred or was ongoing, and that there is the automobile exception in this particular case. As the Court will hear, and I want to address the one aspect in regards to whether or not the 911 tape was part of Exhibit 1. I would direct the Court's attention to the motion to suppress hearing transcript at page 49, which clearly states that both the 911 tape and the turret tapes were Exhibit 1, and Exhibit 2 of the motion to suppress hearing was, in fact, the video surveillance was a agreed to submission to the Court.
Is your brother right, though, that the 911 call was never heard by Hurton before he approached the defendant?
The contents of the 911 call was transmitted by the dispatcher to Sergeant Hurton. Now the specific 911 call, did Sergeant Hurton hear the 911 call itself? No.
So one of the things you rely upon in your brief in response to the arguments is, well, we were told by the victim that she didn't think he was licensed, right? You put that in the brief.
Yes, Your Honor.
A couple times.
Yes.
But in fact, Sergeant Hurton didn't know that at the time that he approached the defendant.
In addressing that issue, Your Honor, I would suggest that the dispatcher received information from the 911 caller who self-identified and provided a great deal of context in regards to what occurred. I would suggest to the Court that that was conveyed to Sergeant Hurton in regards to the defendant or the suspect in this case being in possession of a firearm. I believe it's a reasonable inference to believe that when the dispatcher conveyed that information to Sergeant Hurton without saying he also has an LTC, that an officer responding to a call of a theft, threats, and a gun being present would believe that that person did not have a license to carry at that time. I believe it's a reasonable inference to make in that situation, that a law enforcement officer who has been on the force for several years, who's been involved in drug investigations, been involved in firearm investigations, that being called to a scene involving a theft, involving threats, and a firearm being present.
I don't know, how long does it take to find out whether someone has a license to carry?
I'm sure that it doesn't take very long in regards to a CJIS inquiry, but I do note that the 911 caller specifically stated that they saw the firearm and did not believe he had an LTC at that time. I would suggest that that was sufficient for the officers to have, to convey the information to...
I just think if I was an officer, I wouldn't assume the dispatcher went and checked for the license to carry. They just want me to know whether it's licensed or not. This guy has a gun, so be careful.
Right, Your Honor. I would also cite, too, I believe it's Commonwealth v. Stout, 422 Mass 782, which the SJC in this addresses situations involving firearms. And I would just quote, when a tip concerning the possession of a firearm is made, it deserves the immediate attention of law enforcement officers, which is exactly what Sergeant Hurton did in this situation. He got a call about a report of a firearm, threats, and a theft, and then responded immediately to the scene of the location of the registered vehicle. He then saw an individual later identified as the defendant with his hands in the trunk that was open at that time. And then he immediately approached. This is a situation that he himself had stated that he had been to that location
Did the
hundreds of
dispatch say guns in a silver lockbox?
I don't recall specifically if it identified where the firearm was. I do know that it was referenced that there was a firearm, or there was an allegation that he had a firearm, and I can't recall if
It did say silver lockbox on the turret. It did.
It did. And I apologize, Your Honors. So in regards to the probable cause, I would ask that the court find that the motion judge was properly denied the motion to suppress, because in this particular case, the officers did have probable cause to believe that a crime was occurring or had occurred, whether it was a theft, a larceny from a person, a larceny from a building, unarmed robbery, armed robbery, possession of a firearm during the commission of a potential felony. Under all those theories, the officers had probable cause to believe and search. Additionally, under the automobile exception.
I'm sorry to skip around, but the video exhibit at the suppression hearing, is it the same one as the one that came in at trial, or were they different?
So there was 2 videos that were submitted at trial, and there was, I believe, 1 video that was submitted at the motion to suppress. The motion to suppress video was an enhanced video, I believe, that was prepared by the defense, which the Commonwealth agreed for the admission of at the motion to suppress hearing. Essentially, it was a zoomed-in quality photo or video. At the trial of the case, both, I believe, the undoctored or unedited version of the CCTV footage was admitted in sections based on authentication by the officers who were present at the scene, and then a secondary video was also provided to the jury that had a more enhanced view of the back of the car.
So, I mean, can I ask you to just coordinate with your friend when giving us the video, you know, help make sure we know exactly what it was and where it was and whether it's the same as.
Yes, Your Honor.
You could walk us through that if you guys could work together to submit the videos to us. That'd be really helpful.
I'm happy to work with my brother counsel in regards to providing the court the Exhibit 2 from the motion to suppress. Does the court want also the exhibit from the trial in which there's an allegation involving the Commonwealth's arguments at closing? I can provide I believe it might be a separate video, and there are multiple videos that were submitted, so I defer to the court on that, but I'm happy to work with my brother.
Yeah, no, if you just work together, get us the videos and explain to us exactly what's what, because it's already confusing, so it's going to get even more confusing.
In regards to the motion to suppress, I would just suggest to the court, and I believe that there was probable cause that the officers believed that a crime was occurring or had just occurred, and that due to the automobile exception and that this vehicle was parked in a public place, and the vehicle was open at the time, it was not registered to the defendant, that there was a basis for the officers to conduct the search. And when they recovered the laptop or the tablet.
When did they arrest the defendant?
So the defendant was placed under arrest after they recovered, I believe, the firearm and the other items inside the backpack. He was detained prior to that moment. The moment the officers arrived on scene, they had him step away from the trunk area. They detained him. They placed him in cuffs, and the officers began to search the vehicle. I believe they started from the front. When they started from the front, the defendant then stated on multiple occasions, without being prompted, I can essentially consent to the search of the vehicle. He was being Mirandized at that time. Right before the search even began, the defendant made the statement spontaneously, I took the tablet, but I was going to return it, and I believe makes reference to Hayes Street, which is a location of where the 911 call was made.
So can we switch to the issue of the drug distribution evidence?
Yes, Your Honors. In regards to the drug distribution evidence, I would ask that the court find that there was no abuse of discretion in this case, that the trial judge did properly weigh the evidence, credibility, or the probative nature versus the prejudicial effect.
Where are we going to, if I look at that record of the judge's ruling on that, where am I going to find the judge weighing probative value against potential prejudicial effect?
Yes, Your Honor. I think that it's better explained through the extensive arguments made by by trial counsel in this matter, both by the defense and the Commonwealth, addressing both those issues, because the Commonwealth and the defense both address whether the probative nature of the evidence, the prejudicial
Was there a motion in limine?
There was a motion in limine filed by the defense to exclude, and the Commonwealth.
Was there a lengthy argument on it? Because
Yes,
I
Your
don't
Honors.
recall seeing a reference to
In
that.
regards to trial transcript, I guess, section or packet 1, or I-26 to page I-39, there's also additional discussion on it, I believe, on I-146 that talks about the probative versus the prejudicial effect.
When I go look at those pages, am I going to find the judge weighing the potential prejudicial effect of allowing in drug distribution evidence?
So, Your Honor, I believe what I'm suggesting to the court is that there was extensive arguments made by parties talking about those issues. And then when the court ruled on it, it indicated and clearly stated, I considered the arguments from the parties, and in considering whether or not they're probative, I believe
Did she rule at the time of the motion in limine, or did she hold it in abeyance and then rule at trial? I've read the trial transcript.
She ruled it prior to the trial starting, at the motion in limine stage. So we argued, or the Commonwealth and the defense argued prior to the trial starting at length on the probative versus prejudicial effect of this evidence, the fact that it was for the limited purpose of establishing the knowledge aspect of the defendant's knowledge of knowingly possessing a loaded firearm, or knowingly possessing a firearm that was loaded, and knowing that it was loaded in fact. And this argument was, essentially born from the court's decision in regards to Commonwealth v. Brown, in which the Commonwealth was given explicit instructions in regards to what evidence is necessary to establish the knowledge aspect for a firearm, particularly a firearm that is a handgun, because one cannot readily see if it's loaded based on just looking at the outer appearance. The Commonwealth looked towards the totality of the circumstances on these cases, and in this particular case, we saw that there is a situation where the defendant was in possession of what appeared to be drug distribution paraphernalia. We have an officer who testifies based on his 14-plus years of experience as being a law enforcement officer that involving the illicit narcotic trafficking or narcotic distribution, that individuals in that business do possess firearms to protect their investments. And in those particular situations, I would note that the trooper in this case, who was the firearm expert, further testified that a firearm that is not loaded is I can't remember the exact word he used, but I believe useless or is not useful in some.
How do you distinguish the Little case that your brother cites? So Little is a case where evidence of prior convictions of drug distribution went in, and the SJC held that that was error requiring a new trial because it was more prejudicial than probative, among other reasons.
Yes, Your Honor, and I would suggest to the court that in this particular case, the information relating to the alleged drug distribution as to the limited purpose of knowing that the firearm was loaded was extremely probative in establishing that he knowingly possessed that firearm loaded. And in regards to the Little case, I would suggest to the court that that was involving the use of certified prior convictions, and whether or not the court heard sufficient arguments by the parties to establish what the weighing of that probative versus prejudicial effect. And in this particular case, I would suggest to the court there was at-length argument, both at multiple stages of the motion to eliminate process, where where the parties initially argued it. It was there was I think a continuance to address other issues, and then the Commonwealth and the defense further argued the issue, and the court finally made a determination assessing that there was probative information that outweighed the prejudicial effect based on the fact that it was only for the limited purpose of establishing an essential element that the Commonwealth had to prove in this case. Understanding that the court's decision was, I would suggest, perhaps brief, I don't suggest in any way that the court, in the lower court, the trial judge, did not fully appreciate all the facts and circumstances that were argued by both parties at length on the prejudicial versus probative nature. I would also ask that the court find that in regards to the nature and circumstance of that evidence, the Commonwealth's cases that the Commonwealth cited, I would also cite to Commonwealth v. Moreau, which is 427 Mass 65. In that case, that involved an individual who was an alleged drug dealer who ended up killing or murdering an individual who was the victim. And the motive of that killing was the prior history between the parties, and that the victim was a customer of the defendant. And that court found that it was admissible evidence as it goes towards motive. And I would just note in regards to Bradshaw and...
Which case was that?
The Moreau case, Your Honor, was Commonwealth v. Moreau, 427 Mass 65. It's a 1998 case that's cited in the Commonwealth's brief on page 28. In regards to page 29, the Commonwealth's brief, Commonwealth v. Bradshaw, I would ask that the court also find that that's also a very relevant case in this particular situation. In that case, a significant amount of unrelated criminal activity by the defendant leading up to the murder of an individual establishes the defendant's motive, because those other acts were to essentially collect money that the defendant allegedly lost, and that he then later murdered the last person who he encountered that day. And it gave the jury, it provided evidence to the jury that would at least explain, wouldn't put the jury in a place where they didn't have an inexplicable or unreasoned basis behind what the motive was of that killing. I know that my time is short, so I would defer to the panel if there's any further questions that Commonwealth would rest on its brief.
Hearing none, thank you very much. The case is submitted.
Thank you, Your Honors.
Our third case of the morning, and for those of you in the audience, the last case before we take a brief mid-morning recess, is Commonwealth versus Miranda, 2022 P161. And once again, the Commonwealth has the pleasure of going first.
Good morning. May it please the Court. Michael Locke for the Commonwealth. Starting briefly with the waiver argument, the Commonwealth hasn't waived the argument that the search was good with or without the bolo. This is evidenced by the fact that the motion judge in his initial decision ruled that, or found, discredited the bolo and still found that the search was good. It was clearly contemplated by the motion judge.
Well, put it this way, the judge reached it even if the Commonwealth didn't raise it.
Correct, Your Honor. And I would suggest that it was plainly obvious based on the fact that the gun was found as a result of the search that it was at issue. Moving on to the search itself, the SJC and this court have repeatedly held that where a officer has a reasonable suspicion that a defendant is armed or a suspect is armed and dangerous, that an exit order, a pat frisk, and a limited search of the vehicle is appropriate. It's I can list them off, the cases.
Counsel, we're familiar with the cases.
Some of us more than others.
I was going to say
To the extent the judge found that there was a dissipation of the concern that had been raised by the reaching around, why isn't that to some extent a question of fact as opposed to law?
Because I think the SJC has made it a question of law, that where there is, the question is whether the officer had a reasonable suspicion that the suspect is armed and dangerous, which is a question of law.
But here, I don't think tell me if I'm wrong, but I don't think any of the cases deal with an infraction as slight as this one. By that I mean the civil infraction of a license plate light that was not sufficiently illuminating the license plate. And in Monell, you had a holster. So there was a somewhat profound fear of the defendant being armed. Here, you have at best some ambiguous movements, and you have a license plate light out. After they got him out of the car, searched him, pat frisked him, and put him back in the car to go, I mean, why wasn't the judge justified in saying any concern had dissipated?
Because here one of the facts was that when the officer started walking towards the car, the defendant reached started to open the car door, started to look behind him at the officer, and was reaching towards the center console, where obviously this doesn't come into account, but that's where the gun was actually found. So I think that dissipation language comes from Douglas, because Douglas, the SJC, I would argue that it was dicta, because it was after, even if we assume the pat frisk was good and everything. But the facts were so specific in Douglas, where the officer came up to the car, did not have any suspicion that anyone in the car was armed and dangerous until he got to the car, and there were 2 or 3 individuals in the back seat. And at that point, the individuals did something. I think one of them was reaching for a seatbelt or something, and it was at that point, when the officer was there, that he saw these motions by these 2 occupants of the vehicle, and the movements only related to something that would show that a weapon was on their person. Like I think one of them had their pockets, or their hands in their pockets, and the other one was reaching for a seatbelt or something like that. Here we have the movements start when the police start the stop. When they turn their lights on, the defendant starts dipping already. So now the officers are like, okay, there's reason to believe that he's trying to hide something in the car. It's no longer on his person. That's why he's making those movements. And then when they start walking towards the car, he starts reaching towards the center console, which again is some indication that he's either hiding something in the center console or reaching to get something out of the center console. So it's not on his person. So a pat frisk, when you pull him out of the car, the pat frisk is not going to show that weapon that he might have just stashed somewhere in the car.
Well, in this context, hiding something there isn't good enough, is it?
It is, because it still goes to officer safety, because if you let him get back into the car, he can reach
No,
for
but
that.
it's only if it's a gun. The
Sure.
fact you said,
Sure.
well, but the gun is only at risk if he's
In the
actually
car.
reaching for the gun, correct?
Right, or if he's stashing it, and then they let him get back in the car, and now he has access to a gun.
And tell me, vis-à-vis the concurrence of Monell, how would it be rational for the guy being let go for the faulty tail light or license plate light to then say, oh, now I'm going to shoot them?
I think Your Honor might be in a better position than most to see that there's a lot of non-rational things that people do. Just anecdotally, in Springfield recently, we had officers try to stop a car. They turned their lights on, and they started shooting at the officers before they even stopped the car, without any, no interaction at all. It happens. There's once there is a reasonable suspicion that someone is armed and dangerous in a car, yes, again, the SAC has repeatedly held that officers are allowed to go into that car.
Well, let's talk about rationality. I mean, they did not, before they pulled this guy out of the car, and the testimony was, could you see his hands at the time? No. As I got closer to Mr. Miranda, he opened the door with his left hand, and I made contact with him, and then with his right hand, I could see that his right hand was reaching over toward the center console. Could you see what he's reaching for? No. How did this make you feel as an officer? It was a red flag. It heightened my awareness. That's the testimony that was given, right?
Correct.
They didn't ask him for his license and registration at that time. They're going to give him a traffic ticket. He's going to get back in the same car with the officer present, right?
Correct.
Isn't it very rational under those circumstances for an officer to be concerned that having just reached for the center console, not knowing what it is, he doesn't want to put him back in the car without checking what's in the center console?
Correct, Your Honor. I think that's very reasonable. If there are no further questions, the Commonwealth will rest on its brief.
Hearing none, thank you very much.
Thank you.
Good morning, Your Honors. Reina Ramirez on behalf of Mr. Miranda Gonzalez, along with my mentor, Attorney Joseph Schneiderman. Shortly, I will go to the forfeiture issue, and I would just note that in Betancourt, in a footnote, and I believe it's footnote 3, the court notes that when the entire thrust of the hearing below is different than what they raise at the appeals court, that is a raise or waive situation, and they have waived their argument. I appreciate what you're saying and what the Commonwealth said about His Honor clearly considering other arguments, given that he discredited the BOLO. But I think given that the Commonwealth based their entire opposition motion on the BOLO, based their entire argument at the suppression hearing about the BOLO, that was what they felt carried the day below, and now...
Why are we beyond the issue of waiver when the judge expressly embraced the issue below?
Because I think there is something unseemly, as Justice Greene quoted from the Oregon State, about presenting one argument to the judge below and then a different argument.
But that's not what happened here. The opposition said, below, saw the defendant leaning to the side and dipping down the seat, and attempted to exit the car without being asked to, while still reaching one arm towards the center console. That's 4 arguments, one of which is the below. Are you saying that if someone makes 4 arguments and one of them loses, they can't appeal? Because that's not going to be very defendant-friendly in general.
No, and of course I would not want to do anything that would harm future defendants. But I am saying that when you argue below that x plus y plus z plus a equals 4, and then x is found to not be credible and to be a 0, you don't get to then come before the court and say, actually, y plus z plus a equals 4 still.
Would you say it equals 3, though?
Not in this case. I would say that y in, I don't know what x solves for, and below they were hanging their hat on x, and so I would say x was the 3. Y and z and a are the innocuous observations that add up to a sum of 0 here.
To the extent you're saying the Commonwealth didn't cross every T and dot every I in making its argument below, I, for one, completely agree with you. They did argue the facts about the concern for the safety, and as Attorney Locke was arguing, it's kind of obvious that coming out of that is, can he, for lack of a better verb, pat frisk the car? And the judge went right there. So, I mean, the issue...
But there was also a time period where new case law came out, Torres Bagan comes out, trial counsel below supplements and asks for reconsideration, not only because the court had not received its earlier pleading, but also because of the new case. And then the court had that motion pending with it for 21 months. In the normal course, the Commonwealth should have opposed it, should have alerted the judge that, no, Torres Pagan actually, as defendant is saying, doesn't change your initial ruling, Your Honor.
You know, can I ask on Torres Pagan, you don't hang your hat on Torres Pagan. You don't question, and in fact, you concede, as I understand it, the lawfulness of the pat frisk.
Yes, Your Honor, and I think that's because of the rapidly escalating circumstances, and I'm not arguing, and that's what the judge found it as. Going back to Justice Milkey's earlier.
But then why is Torres Pagan? You need, and you are arguing for a step beyond Torres Pagan. As I may not, the panel may not agree with me on this, but Torres Pagan, for the first time in my view, said there's a difference between what you need to get somebody out of the car and what you need to pat frisk them. You're saying there's not only a difference between what you need to get them out of the car and what you need to pat frisk them, there's also a difference in terms of what you need to show to then go back in the car and look in the car.
Correct, but I'm not hanging my hat on Torres Pagan. I'm hanging my hat on Torres Pagan, Douglas, and Cordero. So in Douglas, which was also mentioned by the Commonwealth in their argument, what the officers knew at the time was that the occupants of the car had been involved in gang activity, had violent interactions before with other groups of people at the party that they were investigating. And Douglas says, after the pat frisk, it should have stopped, but for the fact that officers in this situation knew something about the occupants of the vehicle that justified going back into the vehicle. And that's a completely different gestalt of facts than are present here for Mr. Miranda Gonzalez. Mr. Miranda Gonzalez was driving and pulled over for the very minor infraction of an unlit license plate. When the officers approached the vehicle, they saw him dip down to the left. As Officer Santos got closer to the driver's side, Mr. Miranda Gonzalez opened the door and reached back towards the right.
Towards the center console.
Towards the center console, where people keep lots of things. They did not do any investigation to ask, hey, Mr. Miranda Gonzalez, what were you doing? What were you reaching for? That may have or may have not developed additional facts that, like in Douglas, would have allowed them to get back into the car. But once the pat frisk revealed nothing and dissipated the fear, they didn't have an automatic right to go back to the center console without more. And I point to the cases that the Commonwealth hangs their hat on. such as Savello, where they actually see a gun or weapon-shaped object fall out of the defendant's pocket. That is a completely different case than this. They don't see anything. And again, in Monell, a holster. Well, where there's smoke, there's fire. Where there's holster, there's a gun to be holstered.
Oh, go ahead.
So why can they pat frisk him? I don't understand, under your view of this, why they suspect him to be armed.
I'm sorry, that last
Why
word?
do they reasonably suspect him to be armed such that they can pat frisk him?
My position is that the pat frisk was marginally allowable, and that this court does not need to actually rule on that, because at the end of the day, what was certainly clearly not allowed is the pat frisk of the vehicle and opening the center console. If there was something near the center console that said, like a holster, like in Monell, that might have given them more reason to open the center
I
console.
worry that you're really asking officers, you're just slicing it so thin. You know, we're trying to give direction to people who are operating in the field. They're not trained lawyers. They have to make spot decisions that have to do with whether they're going to live or they're going to die. And this, if you say, as I understand it, concede, this officer had sufficient information to believe that this person was armed and dangerous, therefore had the ability under Torres Pagan to pat frisk them. Don't they also, when they're going to put the person back in the car and talk to the person, have the ability to check around the car to make sure the guy isn't going to have something that can shoot him?
And if they saw something in plain view, then they would have gotten to the center console, but they didn't see anything in plain view, and the defendant himself did nothing to make officers feel...
And what case is going to tell us this, other than potentially my esteemed colleague's concurrence in Monell?
I think all the cases say this. I think Daniel at 464 Mass from 2013 indicates that traffic...
What's the rest of 464 Mass what?
It's a 2013 case, so it's 464 Mass, and the page is 746. And in that case, the court held it's unreasonable for police to spend time conducting warrantless searches for contraband when no specific facts suggest criminality. And further, as citizens, we expect that if we commit a civil infraction, we will pay a fine. We do not expect a significant intrusion into our privacy or our liberty. That's a 2013 case. You don't have to upend Torres Pagan or make a new announcement. I think reading Daniel together with Douglas, Silvello, Monell, and Torres Pagan gets you to affirming the lower court's suppression of this firearm.
Could you directly address Judge Englander's earlier recitation of the facts in terms of after the pat frisk, the police still did not get the license and registration. They were putting him back in the car. There was testimony that he was reaching toward the center console. Why doesn't that, as a factual matter, establish that the risk was still present?
Well, I don't know that they were at that point putting him back in the car. He was at the rear of the car and he was detained separately. They go right to the car to search for the center console. They don't do anything to complete the traffic stop. I submit...
Are you suggesting that they should have completed the traffic stop outside the car, like I believe they did in Monell?
I am suggesting that they could have and should have continued with the investigation into the traffic stop, and if they had concerns, they are able to ask the defendant, where are you going, where are you coming from, why were you dipping down? And if he gives answers that don't make any sense, if he explains nervousness, those would all add more facts to the gestalt here. That's not here.
But none of that's necessary. I mean, in fact, under the way you would view the case, and probably the way I would view the case, they've pat frisked him. He has no weapon. They don't have to ask him any more questions. He was stopped because he didn't have a light on the rear of his car. The next thing that would happen for most of us is go back in the car, give us your license and registration, we're going to write you a ticket, right?
I would,
I mean, isn't that a fair assumption from this evidence, that the next thing that would happen is that they would have to put him back in the car?
I do believe it's a fair assumption, but it's not what happened here. And when officers act in a hasty manner, they act contrary to what the court allowed in Commonwealth v. Stampley. In that case, the defendant had bent over for 45 seconds. That was the count that was testified to. And still, officers in that case said, I'm going to keep an eye on that. I'm going to call for backup. That's another feature of cases that when that's not present here, is that when there are concerns for safety, they call for backup or they radio it into dispatch. And the feature of, or the sort of the touchstone of this analysis is reasonableness, and acting in haste in this situation with as few facts as were present was simply not reasonable. And so that's contrary to the cases, including the 2002 case of Commonwealth v. Stampley. I think unless the panel has further questions, I would just ask that this court affirm the lower court's finding of suppression, and I thank you for your time.
Thank you both. The case is submitted. We will now take our brief mid-morning break. We'll be back here by 11:20.
All rise, please.
Well, we almost made 11:20. We are back on the record for the fourth case of the morning, 2022 P282 Gatehouse Media LLC versus City of Worcester. Mr. Pyle.
May it please the Court, Jeffrey Pyle for Gatehouse Media LLC. In 2016, the legislature substantially revamped the public records law. And the most important thing it did was to impose a presumption of attorney's fees for almost every requester who prevails in court. And it did that for a number of reasons. It wanted to ensure that municipalities and agencies would be transparent. It wanted to impose a cost on them when they aren't and when they violate the law. And it wanted to encourage plaintiffs and attorneys representing potential plaintiffs to bring lawsuits when it's appropriate under the records law for enforcement.
But obviously, it doesn't mean you get all the fees you request.
And I would never argue that it would, Your Honor. However, here, Gatehouse requested a number of different records from the city, and after a hard-fought 3-year litigation, completely prevailed. It got every single record it wanted. Yes, Judge.
I'm struggling with that, and I think it's important, okay? When you first requested internal affairs records, I think there were 12?
12 internal affairs records and then concise.
4 of them had ongoing investigations at the time?
Yes, I believe that's correct.
Under F, wouldn't the city have been valid in refusing to produce at that point?
We don't believe so, Your Honor.
Why?
Not if the release of the information would not prejudice the ongoing investigation. There's no absolute investigatory exemption under the public records law. The way that exemption is phrased, it says only if release would so prejudice the possibility of effective law enforcement that its release would not be in the public interest. That is a case-by-case.
We don't know the answer to that question, correct?
The court never had to pass on the question of whether or not these records, if they had been released back in 2018, would have prejudiced the ongoing investigation.
Was there briefing on that particular issue early in the case?
There was briefing on that issue at summary judgment, yes, Your Honor. And it was the city's burden to demonstrate that the release would prejudice the ongoing investigation.
My point is maybe the city was right.
Well,
with respect to the ongoing internal, when you say we completely won, okay, you're viewing it from hindsight. 3 years later, you got everything. Part of the reason you got everything is because those internal affairs investigations that were ongoing at the time you asked for them had been concluded, right?
Well,
and just to put all my cards on the table, I'm really trying to get a sense of, did you push for things? So one of their arguments is, hey, you lost. You lost when you sought expedited. You lost on your preliminary injunction. You lost on your motion for summary judgment. So you shouldn't get money for that. And you say, well, it was all directed to the same end. It's you guys who were throwing up, lousy defenses here. And so we should get everything. All right, that's sort of the rough bidding. And what I'm trying to evaluate is, well, really, would you have prevailed on everything?
At the preliminary injunction stage, which they say we shouldn't recover for because the court denied the preliminary injunction, we weren't even talking about the investigation files at that stage. We were talking about the concise officer histories, and exemption F wasn't really at issue. The exemption they were claiming was this bad faith exemption D argument that they made throughout the case. And so we clearly ought to get...
D is the discretionary function exception?
The discretion, the policy positions function, which they said enacted this broad exemption for anything that is possibly related to ongoing litigation.
Yeah, I know what you're talking about.
And the court ultimately found that was in bad faith. At summary judgment, the parties agreed that there were no material facts in dispute and that the court could decide the issue as a matter of law based on the factual submission and legal submissions given, but the court just denied both cross motions and marked the case up for trial. And that was part of the reason this case lasted so long, is because the summary judgment judge did not just take the records, look at them, and decide the legal issues at summary judgment. The judge at summary judgment decided.
So F came up, at the time F came up at summary judgment, were there still ongoing internal affairs investigations?
Your Honor, I don't think that the record is clear about when precisely those internal affairs investigations concluded. I believe that there might have been one or two.
Did you have discovery before summary judgment?
We did not have discovery before summary judgment.
And why is that?
We determined ultimately that the facts that, first of all, it's the Commonwealth's burden, or it's the city's burden to show that an exemption applies. If any party is going to be making a factual presentation, it ought to be the party with the burden of proof. Yes,
Did they make a factual presentation at summary judgment where they said, part of the reason we're not providing all the documents that you're seeking is because we're invoking exception F because we have ongoing internal affairs investigation?
The affidavits of Attorney Quinn and Attorney Thompson at the summary judgment stage are in the record. I don't recall that they specifically invoked that at summary judgment. It may be that they were concluded by then, but they still maintained that they were exempt even after the investigations were over because they had to do with ongoing litigation. So we wouldn't have gotten them at the end, at the conclusion of the investigation anyway, because they said we get to withhold them if they even are relevant to a civil rights litigation. And that, the court ultimately held, was in bad faith. And by the way, you know, this particular issue we're talking about doesn't come up in the judge's decision slashing our fee request by 50% at all. The judge did not cite that as a reason for the cut. And the city argues it now.
Well, maybe, but the judge was aware that F was an issue because the judge didn't resolve it, right? If I'm remembering, on the 35-page opinion, the judge basically at that point punts on it, says, I'm still not ready to decide this.
Well, at the summary judgment, at the end of the case, that may in fact be correct, Your Honor. But the ultimate basis for the court's slashing of the request, which is what we're appealing here, is that the legal briefs at the various stages, the best we can determine, she said, based on the billing as a whole, I think that a 50% cut in hours is reasonable. And that essentially is the extent of her analysis. There are a few criticisms of our bills along the way, but no explanation as to why those criticisms add up to
the case law is fairly clear that a judge considering attorney's fees, be it a trial court judge or an appellate judge, doesn't have to go line by line to the items, that they can make more of, for lack of a better term, back of the envelope assessment. And especially where the judge saw the trial court proceedings, knows the case, knows the attorneys, how did she abuse her discretion? And putting aside for the moment the two items that she said you don't get anything on.
Okay.
But on the 50% reduction, how is there an abuse of discretion?
3 reasons, Your Honor. First, her factual findings are erroneous in important respects. She finds that the legal issues at every stage of the case were virtually the same, she said, and reduced the hours spent on legal briefing and research accordingly, and said that there was too much time spent on that. They were not virtually the same at every stage of the case. The PI motion, as I say, dealt with only a small portion of the records. The summary judgment motion dealt with a great deal more issues. More work had to be done at the summary judgment stage. When you read the pretrial memorandum, which the judge specifically requested, we dealt a lot with the expected evidence at trial and exhibits and the like, and a new argument from the city about mootness and the city's Vaughan index, which we said was inadequate. Then the post-trial memorandum, which she says is one of these duplicative briefs, spent most of its time summarizing the evidence that had occurred at trial. So she was literally criticizing us for doing the things that one must do in order to bring a case to conclusion. So that's one reason that this is an abuse of discretion. Another is just the absence of sufficient findings to facilitate appellate review. The cases do say, yes, Your Honor, a percentage-wide across-the-board cut can be made. The court need not put on a green eye shade and go through each bill line by line. However, when one slashes a fee request by 50%, or a significant amount, the court is required to make findings that enable effective appellate review. And we've cited a number of cases that have said when you do an across-the-board cut based on a bunch of different reasons, you ought to assign a specific percentage to each reason so that we can actually determine whether that assignment was reasonable or not. But essentially to throw it all into the soup and say, I think that half of what you're asking for, or less than half of what you're asking for, is reasonable, is not enough under the case law. And the third reason she abused her discretion is that she did not consider the public policy implications of what she was doing. The legislature, when it passed this statute...
But, counsel, isn't that baked in to the fact that there's not only the opportunity to get attorney's fees, but as you point out, a presumption that you get attorney's fees? Why does a judge then separately have to consider the public interest aspects?
Well, Your Honor, we attach an appeals court decision, Franks versus Mitchell, where the court similarly looked at a drastic fee reduction in the anti-SLAPP statute. And
I'm not sure the 50% reduction is quite as unusual as you seem to think it is.
Well, Your Honor, it may not be unusual. However, when you have a statute that is intended to actually bring about an important public policy outcome, which is increased transparency over serious allegations of things like police brutality and municipal corruption.
Well, why isn't that true of all the fee-shifting statutes, like the various civil rights statutes?
It may not be true of like the lis pendens the fee shifting, or there's a number of fee shifting statutes that don't necessarily involve matters of such weighty public interest. But on the civil rights side, plaintiffs are incentivized to sue because of the possibility of recovering compensatory damages. That may be a better, a sufficient angle to bring a lawsuit. Whereas here, all you get when you're a plaintiff in a public records case is the records themselves. And if records requesters think that they have to pay hundreds of thousands of dollars to get public
I think we understand that argument. You said there were 3 points?
Yes, Your Honor.
Go ahead and make the third.
The erroneous findings, the lack of sufficient findings to justify the cut, and then the failure to consider the public policy.
Can we talk about the appellate fees? Fees for appeal. The Stratos case that you rely on seems to say that you don't get fees for appealing a fee request unless the original fee was plainly unreasonable. Do you agree that's the standard?
If that's what Stratos says, Your Honor, I agree that that's the standard. We rely on Stratos. And we do submit that this fee award was plainly unreasonable.
What do we do with your appellate fees request if you get partial success here? We don't jump it up to, we don't jump it up to, twice what it is now, but maybe you wind up with, 10% more. What do we do with the appellate fees situation that?
Well, I think, Your Honor, if the court were to reverse the Superior Court's decision, the court would be remanding to the Superior Court.
Why?
Well, that's how it has worked in other appellate cases.
There are a lot of First Circuit cases that have just picked a number.
And Your Honor, if this court were to, looking at the records before it, decide to go that way, we would have no objection to doing that. We want to get this wrapped up as...
All right, so we give you 1/5 of what, on Judge Ditkoff's hypothetical, we give you 1/5 of what you're looking for. And then we give you 1/5 of the appellate fees that you're looking for. Do you then go FAR because you're very disappointed that we only gave you 1/5?
I doubt very much I would do that, Your Honor, but
the point actually is broader, right, counsel? Which is, here you asked for X and you got 0.46X.
Right.
And you're saying that's fundamental error.
We say that's fundamental error. I think that to answer Judge Ditkoff's question, I think that if we reverse the court at all, we ought to get full appellate fees, because the notion that you can get only a partial appellate fee if you're only partially successful would discourage people from appealing, and therefore allow for these kinds of unreasonable fee awards down below to be less than properly
exactly what I was
appealable.
getting at.
But the question of can the court simply assign a number based on its review of the records? We do think the court may have the power to do that.
Okay, let me ask you a specific question on the fees related to the motion to expedite. The judge used some arguably inartful language saying this was unrelated to the George Floyd matter, but putting that aside, why isn't it within the judge's power to say this was a misguided effort? Here we're in the middle of a pandemic. Unlike a lot of parties, you got a trial on a fairly expedited schedule, that the separate litigation over the motion to expedite was a, for lack of a better term, dumb idea, and I'm not going to give you anything for that. Why isn't that perfectly appropriate?
Because we were not moving for an earlier trial date. We were moving to expedite the case in such a way that would have avoided a trial. We were trying to, from this very beginning, Your Honor, we were trying to try this case as efficiently as we could. We asked for an early ruling on the preliminary injunction question and didn't get one because the court decided not to.
Trying to get them to decide the legal issues that were there.
We were trying to get the court to decide the legal issues and have the parties confer and narrow the issue so we didn't have to go to a 4-day bench trial in the middle of a pandemic and waste the court resources.
Okay, but the case went to summary judgment and the judge denied both sides.
Correct.
This question is going to sound more impertinent than it's intended to be, but if you're correct that the judge should have resolved this case on summary judgment, why should the taxpayers of Worcester have to pay for that?
The taxpayers of Worcester cross-moved for summary judgment against us, and their cross-motion was denied. So if you had just taken that motion, we'd be going to trial, of course, because
no, I understand.
That's what they were seeking. But if it should have been decided, the public records requester, who is trying to carry forward the public interest in transparency of alleged police misconduct, should not be the party that suffers the consequences of the summary judgment judge's decision not to decide the case. The city at any time could have released these records. The city at any time could have followed the 2003 Worcester Telegram and Gazette precedent that said that these are public records. It chose not to do so. And that's why the city is liable for everything that came after that decision and everything that came before it.
I have one more question, and it's this. You seem to agree, and in fact you mentioned it in your brief, that it was appropriate, or that it could be appropriate, could have been appropriate for the court to cut your fee request by some amount. What amount? How much would have been appropriate? 50%, 54% is not. What would have been appropriate?
In the typical kind of haircut you see in the cases is maybe 10 to 15%. That's the kind of cut that I would have conceded would be perfectly appropriate under the circumstances. To cut it by 54% sends a message to public records requesters: don't bother suing, you're not going to be made whole, even if you win, and show that the other side acted in bad faith in withholding records from you. That's the message that we want, that we ask this court to send.
Counsel, we've already run over. Thank you very much. We will hear from the city.
May it please the court. Wendy Quinn on behalf of Appellee City of Worcester. Gatehouse Media here seeks to overturn an attorney's fees decision of the Superior Court when the decision was discretionary and there was no clear error. Here, Gatehouse must show that there was an abuse of discretion, that the Superior Court took an action that no conscientious judge acting intelligently...
Counsel, that standard is no longer in effect since...
I apologize, Your Honor.
LL versus Commonwealth.
Thank you. I think...
Outside the range of reasonable alternatives.
Yes, Your Honor, thank you. I think here, though...
Or error of law.
There's no clear error, right?
Or error of law.
Of law.
Okay, so aren't they entitled under the case law to at least some fees for seeking their fees?
I would say no, Your Honor, because the Gatehouse has not shown that there was a clear error of law in this.
No, but they had to put together a fee petition.
Yes.
And the case law recognizes that, at least as a general matter, they get something for putting together the fee petition. Neither side has addressed the fact that typically the rate they get for that is lower than the general rate, but how is the judge entitled to say, okay, I'm not going to give them anything for this? She didn't say it was non-compensable, but she did say the request they made was unreasonable. But for that, she didn't give a 50% reduction. She said nothing.
I think, Your Honor, because that was a ministerial task, and that was sending a clear message that...
How is it a ministerial task where you folks, I'm looking at it, you filed like a 20-page opposition to the fee request. It's not a ministerial task anymore. They had to do the work. And that's the problem, if I can get on my little soapbox for a moment. They had to do this work because they made a public records request, at least a significant part of which was totally legitimate. And they'd made it 3 years before they got their documents. And they had to do the work. And for the city to be opposing at every level in ways that have been found to be in bad faith, shouldn't they get some fees for that?
Your Honor, I think that, first of all, I would like to address that. This was a different case than had been decided in the past in 2003 by the appeals court in the Worcester Telegram and Gazette case. At issue in that case was Exemption C, which was the personnel exemption.
Mm-hmm.
Here, this was a very different set of facts that had
Why?
not been confronted because this was a public records request by a court reporter prompted by a letter of plaintiff's counsel to the district attorney complaining about defendant police officers in civil rights litigation.
Mm-hmm.
So this is pending civil rights litigation that the attorney was complaining about, and then the
Are they
reporter-
asking for public records or not? That's the question before you. Are they asking for public records?
And
If they are, they're entitled to them. If they're not public records, because there's actually an exception that applies, then they don't get them. That's the only question before you. It doesn't really matter what the context is, does it?
It really did in this case, Your Honor.
Why?
And because the city believed in good faith that that Exemption D applied for deliberative process because of the ongoing civil rights litigation. And this was...
How was their policy making going on? And was that ever expressed? Because the judge, when she finally got to it at the end of trial, 2 years later, whatever it was, said, I still don't understand why they're invoking D. That's what she said.
And frankly, we did struggle with this because no public records case had presented this exact set of facts, where we're talking about police records that were records that had directly to do with defendant police officers in this civil rights litigation, records that were at the heart of those cases and litigated in those federal court cases and subject to protective orders in those cases. There had been no precedent for that position.
The protective orders were so the plaintiffs didn't take the documents and go send them to the papers, but the protective orders don't protect you. They don't protect you from a public records request, if they're public records.
But it was the struggle between why should the newspaper have a greater right of access to those records than the defendants and than the plaintiffs in that police litigation.
Because the legislature created the public records.
And they don't have a greater right. They have exactly the same right. Anybody could have made the public records request, and they would have had exactly the same right.
But
You couldn't have objected in the public records request and said, this is subject to litigation, which is essentially what you did. And the judge said it's not an appropriate exception.
I recognize that the judge ultimately ruled against us on that exemption, Your Honor, and that is why, because when that decision came in June of 2021 on that main exemption, Exemption D, the city, 3 years had passed since the original requests were made, and at that point, the landscape had changed. We had certainly police reform law had been in place. We had resolved the number of the civil rights cases, so that those were no longer an issue. And so we turned over the records at that point with minimal redactions just for personal identifying information. And so...
Yes, because I do understand a little bit of this. No, not nearly as well as the two of you understand what you litigated for 3 years. But when the request was initially made, I think there were 12 internal affairs, and 4 of them were ongoing. And was F invoked at that point? And was F argued at that point as a basis for the withholding by the city of at least those internal affairs proceedings that were ongoing?
At the time of trial, Your Honor?
No, at the time they were initially asked for.
At the time the initial requests were made, yes, there were a few of the investigations were still pending with the police department.
And was F invoked? Was
Yes.
exception F?
Yes, Your Honor.
So,
with regard to 3 of the investigations.
if I asked you this question, how would you answer it? What did the plaintiffs request or push for that they were wrong about?
With regard to the exemptions, Your Honor?
With regard to the case? I mean, one way to look at this is the plaintiffs asked for whatever it was, 12 of these and 17 of these. They were entitled to all of them. What the heck did you spend 3 years and hundreds of thousands of dollars fighting over it? They should have gotten them. If you had a defense, I'd like to understand what the defense was. What was your best defense? What were they wrong about? Anything? Because they say, hey, we totally won. At the end of the day, we got everything.
And that it was unfortunate that the Superior Court disagreed with us, but at the preliminary injunction stage, the Superior Court agreed with the city that this exemption D was the main exemption cited, but also exemption F, to withhold some records in their entirety. And at that point, is certainly the risk to the defense of the police officers was seen by the Superior Court as an important risk, and that perhaps the plaintiff would not be able to establish the likelihood of success on the merits of the claim.
What is it about these documents that labeled them interagency or intra-agency memoranda or letters relating to policy positions being developed by the agency?
And it was really the cases that say that during ongoing litigation, that policy positions may be developed in the defense of that litigation, so that certainly a public entity shouldn't be put at a strategic disadvantage merely because it is a public entity in an adversarial litigation.
But what we're talking about were not memoranda or letters relating to policy positions, are we? Perhaps if you had the ongoing internal affairs at the time, is that the point?
And those were certainly pending throughout a good majority of this litigation. But it was, certainly exemption D, we, in good faith and in reliance on advice from the Supervisor of Public Records Office.
Which exceptions did the judge actually find bad faith assertions? There are 2, I believe.
Well, it was at some point the city also relying on prior litigation with the Telegram and Gazette had relied on exemption C to withhold the conclusions of the investigations. It was in that prior Superior Court litigation that the Superior Court judge allowed the city to redact those the conclusions of the investigation.
Isn't that exactly what the court said was bad faith? It was a bad faith reading of the Worcester Telegram and Gazette case to conclude you could redact the conclusions of the internal affairs.
That is what this Superior Court judge found.
You think she was wrong about that?
Appropriate. We certainly thought we had a good faith reliance on a prior Superior Court decision. And in any event, the city had changed its practice with regard to that exemption by the summer of 2020.
Could we switch gears a bit? You've heard the plaintiffs argue that the judge erred when she said it was substantially the same issues at each phase of the litigation. The PI, the summary judgment, pre-trial memorandum, post-trial. What's your response to that specific argument?
I think that's exactly right. It was the same exemptions, cited at the initial response.
What was right, that the judge was correct that it was the same?
Yes, that the issues throughout the litigation remained the same. It remained the same at the preliminary injunction stage for the most part. I mean, although the plaintiff was pressing for the complaint histories at that point, the issues that were argued throughout the litigation were the same ones cited in the city's response to the public records request in 2018. So,
What was the defense to getting the complaint histories?
I'm sorry, Your Honor?
Complaint histories, as I understand it, those are with respect to things that have already happened, right? They are summaries with respect to each officer of their history with respect to an internal affairs matter, right?
The complaint histories were at the exact heart of the civil rights litigation in the Monell history.
So the defense was?
The defense was that deliberative process exemption should apply to that.
But weren't they summaries of things that had already happened? They had been completed?
They were already completed, Your Honor. However, the litigation itself in federal court was ongoing. And during that litigation, those issues of the complaint histories of the officers, that was an ongoing deliberative process. And
how could it be something that was being developed, which is the language of the statute, if it had to do with something that was already completed?
And I would, again, rely on the cases that say that the DeJesus case primarily, which talks about how ongoing litigation is when a deliberative process is ongoing and incomplete because of that litigation pending.
I have to say, having a little experience in this area, that position, I can understand the judge's concern over the good faith of it. And, you know, at 10,000 feet, what happened here is a newspaper wanted to write about something, and it took them 3 years to get the documents they wanted to write about. That's success from the perspective of Worcester. The Worcester Police Department succeeded in causing the newspaper not to have the information it was looking for over 3 years.
And when litigation was resolved, Your Honor, we produced the records as the litigation was.
Could you address specifically the costs related to the motion to expedite? Because saying that these concerns are unrelated to the George Floyd matter seems wrong.
Well, that's exactly what a different Superior Court judge found in denying the motion to expedite, Your Honor. I think it was unrelated because we were talking about records that had to do with past complaints of police officers.
What does that mean, unrelated, in this context?
I think that certainly it had to do with specific cases that were pending and with civil rights defendants as police officers, but they did not have to do with generally with anything related to George Floyd or the.
Maybe not specifically, but to the extent that there is a reckoning over these issues, and this case relates to the very same kinds of concerns, why aren't they quite related? I'm not saying that answers the question of whether it was a misguided effort or not, but.
And I think in the context of this case, though, too, I mean, we were in the midst of a pandemic. The deadlines had already been set. The Gatehouse had already been denied the records at summary judgment, and a pretrial conference was set. It was certain that this case had to go to a hearing in order to be fully decided, and in order to have an expedited production of those records at that point would have meant that the case would have been decided at that point. But the Superior Court had already found that it needed to go for a full hearing before that decision was made. So an expedited production of the records was trying to circumvent that date that had already been set by the Superior Court.
The statute contemplates that this should be done expeditiously. I mean, it literally says that. And then to criticize them for trying to expedite the process in the face of that particular set of very public circumstances that we're all aware of, how can they be criticized for that? That's their job. Their job is to write about the things that people care about. And right then, they cared about that.
In the case.
So
in the
why
case
shouldn't
itself-
we, when they ultimately succeed in the litigation, why shouldn't they get their lawyers' fees for trying to do what it made perfect sense for them to try to do?
Well, two Superior Court judges disagreed. The case had already had its deadline set. And so it was trying to circumvent that deadline that had already been set by the Superior Court for a full hearing.
Thank you very much, counsel.
Thank you, Your Honor.
The case is submitted. Our next case is 2022 P275, John Moriarty and Associates, Inc. versus Zurich American Insurance Company.
Good morning, Your Honor. May it please the Court, Michael Mahoney for John Moriarty. Your Honor, just to get straight to the issues, I will present today how the complaint should not have been dismissed. It was a well-played complaint. The trial court did not assign the facts in the light most favorable to us. The complaint had a number of exhibits, and it simply was improper to dismiss a complaint for declaratory.
Can I ask a question about the dispute, apparent dispute over whether or not the legal bills had been paid?
Sure, Your Honor.
You say, oh, well, we allege that they weren't paid, and therefore the judge, for purposes of 12b-6, has to accept that.
Correct.
Well, one sort of practical exception to that is on mootness. And to the extent they were saying this case is moot because the bills were in fact paid, I believe there are cases that say that a judge could look to that. So were the bills paid or not?
At the time Moriarty filed the complaint,
They had not been paid.
They had not
I understand
been paid.
that.
How long had they been outstanding at the time you filed the
They were
complaint?
sent to Zurich in July of 2020. The complaint was filed, I believe, in October of 2020. No, excuse me.
October of
No, the
2021.
complaint was filed in February of 21, excuse me.
February 21.
February 21, and they were paid 15 months, Your Honor, after the bills were sent.
So
8 months
the
after.
complaint was filed 8 months after the bills, and they were paid 15 months after the bills,
That's correct.
and after suit had been filed.
That's correct. So similar to the argument that I just overheard, the court questioning Gateway Media, why they should be entitled to costs at the appellate level, we wouldn't have got those legal fees unless we had filed suit. And
No, so if I understand it, if they had put it in terms of this case is moot because, the response would have been, it's not moot because now they owe us attorney's fees for having to have filed the suit in order to establish our right to a defense.
that, and because the dismissal was premature, because the court did not declare the rights of the parties. The court ignored our complaint with regard to the additional insured argument. The court ignored our complaint with regard to the breach of contract. It didn't even address the reservation of rights issue. And the court ignored our complaint with regard to 93A, 176D. And 176D says if you force an insured to file suit to get coverage for the claim, and coverage for this claim, I'm mixing metaphors here, but
So it seems that what you want now for the declaratory judgments is a statement, not that they have a duty to defend, but they have a duty to defend without reserving the right, or without reserving the right to recoup. Is that right?
that's exactly right, Your Honor.
So
And
where did you tell the Superior Court judge that that's what you wanted. It's not in your complaint.
The complaint asked the court to interpret the additional insured endorsement, asked the court to interpret the reservation of rights, and also asked the court to interpret the subcontract between Moriarty and P.J. Spillane. And the court ignored all of those requests. So those are three specific actual controversies. Originally...
Well, so in the complaint, for count 2, you asked for a declaration that you're an additional insured and they have a duty to defend and indemnify you.
That's
now,
correct.
you don't say anything about a duty to defend without a reservation of rights. You just say a duty to defend. And the same thing's true of count 3. Now, not necessarily that your complaint has to be the end-all, but I didn't see it in your opposition either, that you were asking the judge, hey, wait a second, because the judge interpreted this as they just want a declaration of duty to defend, duty to indemnify. Duty to defend's agreed, duty to indemnify is premature. Where did you tell the judge you wanted a declaration about the reservation of rights?
The entire complaint has to be read, Your Honor, in the light most favorable to my client. The facts outline the shifting positions on the reservation of rights. First, when we presented the claim to Zurich, there was no reservation of rights. Then when a subcontractor made a claim for contribution and indemnity against us, we submitted that to Zurich, and they issued a reservation of rights and attached a right to recoupment, which there's no provision in the policy for that whatsoever. This is an adhesion contract, and they can't just assign those terms to the policy. Then that cross-claim by Triple G's was withdrawn. We asked Zurich, and this is all outlined in the factual setting of the complaint, we asked Zurich to withdraw the reservation, and they ignored us. So to answer your question, Your Honor, we're entitled to the benefit of a review of the pleadings from a broad form.
Isn't your better argument that just that's implicit when you're saying you want a declaration that they have a duty to defend you? That's unconditioned. It's you don't have to spell it out that, oh, and without a reservation of rights.
You've said it much more succinctly than I did, Your Honor.
But how is the judge supposed to know that's what you wanted?
Because it's outlined in the facts, and we asked for a declaration of the rights of the parties as per the contract. We specifically outlined the additional insured endorsement, which says that we're entitled to coverage when a claim arises out of operations. The case law is clear on that. The Transamerica case addresses that our operations are not Spillane's operations, and we're entitled to coverage. That was the basis for the reservation, as I understand it, that Zurich issued.
Let's explore how live the dispute about the reservation of rights was at that time. In what way does knowing whether they can reserve the rights or not affect you at the time that you filed the complaint?
In what way does it affect Moriarty?
How does it affect your rights at that point? What would you do differently if the reservation was gone?
None of what I'm about to say is in the record, Your Honor, but for having defended Moriarty, they have a large self-insured retention for all these claims. And if they don't have any coverage with Zurich, they're going to have to set their reserves accordingly. So that would be under their own policy. They then have to try to pass this claim back on to their own insurer. So, and the fact that this complaint was dismissed because it was determined that it was premature to address those issues is simply wrong as a matter of law. There's plenty of case law on that, but I specifically would refer the court to the FRE case that was decided by Judge Murtaugh years ago, and I think it was 2004, where he did not dismiss a declaratory judgment action, and there hadn't even been a personal injury complaint filed giving rise to the dispute for indemnification. So to suggest that the complaint was moot, A, because they had paid the legal fees after we filed suit is wrong as a matter of law, and to suggest that the complaint was moot because the factual determination, as the trial court said, needs to be determined whether or not the plaintiff in the underlying case was injured.
Well, no, I'm trying to figure out is whether there was an actual controversy about the recoupment. I mean, because there's a lot of things that have to happen before there could be a claim for recoupment. And so I'm trying to figure out whether there was an actual controversy at the time that the judge decided it, and that would mean it'd have to affect something that's going on now or then.
I would rely upon what I said a moment ago with regard to Moriarty's reserves. It would need to know whether it was going to have to pay these legal fees back to Zurich. And so that's an actual controversy. And the
More accurately, you would like a resolution of an uncertainty as to whether you might be
that's the Nelson
obligated
case.
To repay the costs.
That's exactly right, Your Honor. That's the Nelson case. And I lost my train of thought for a moment. I'm sorry.
Can I ask, well,
Sure.
I have other questions, so I don't know if Judge Ditkoff has more.
I mean, certainly more questions, but not on this topic.
So then let's just jump into some of the merits a little bit for a moment, just so I understand positions. What do you say to their position that there's law that supports the position that under the language of the policy, they don't have to pay unless, as I understand their position, unless there was negligence on the part of P.J. Spillane?
I say that's wrong as a matter of law.
Okay, so they say your ongoing, liability arising out of your ongoing operations, that's referring to P.J. Spillane's ongoing operations, right?
That's right, Your Honor.
And you would say, oh, that's broad. Anything that arises out of their operations. Well, this surely did because the guy was walking on the job site trying to do his job. And they would, I think, say they've got some case that suggests, no, that language actually means that it has to arise out of a fault on the part of P.J. Spillane.
Your Honor, I cite to the cases interpreting AI policy language, which are
But why does that matter? There's a statute. This is why you didn't get summary judgment on indemnification in the underlying suit. There's a statute that says that it's void to the extent it imposes liability without P.J. Spillane being at fault.
14929C, Your Honor, right.
I mean, so it doesn't really matter, and the contract specifically says, and we adjust this to whatever the law requires, because they knew it would just be struck as void if they didn't put that in.
Okay. Judge Ditkoff is a mile ahead of me, as is frequently the case. There's a statute that says that the insurer is not going to have to pay unless P.J. Spillane is at fault? What does the statute say?
The statute says 149, first, this was not addressed in the trial court papers, and unfortunately, it's almost as if we're doing the DJ in the appeals court, but that statute says that Spillane would not owe any indemnity unless the negligence arose out of conduct attributable to their employee. They have to be negligent. Spillane can't be negligent because of the workers' compensation exclusivity
Well, they could be
clause.
negligent. They just can't be found liable for negligence.
Right.
But they could be found to be. I mean, you're going to get a judgment in the underlying case on the indemnification claim that's going to tell us whether this action was caused by P.J. Spillane. That's the end of this.
If I may, Your Honor, just two more points to answer your previous question. One, arising out of is broader than caused by, and I again rely upon the cases cited in our brief.
But why does that matter when the statute says you got to get caused by?
Because arising out, because we're determining whether or not there's coverage under the policy, not whether or not there's indemnification due from Spillane back to Moriarty.
You don't have a policy with them. The only way they have to defend you is if the indemnification claim is seasonable.
I would disagree with that respectfully, Your Honor, because we have the AI endorsement. That makes us an additional insured. Your means yours for Spillane and your for JMA.
Isn't there even a simpler answer, which is the duty to defend is
Broader.
separate from and broader than the duty to indemnify?
Once again, Your Honor, you were much more succinct than my argument.
And to the extent that we're talking about a DJ on the duty to indemnify, why wasn't the judge correct, at least as to that claim being premature? You've got this trial out here that's going to resolve a lot of this stuff.
She may have, but as you just said, she may have been, well, actually, I'm not going to concede that, Your Honor, because I'm going to rely on the cases that say that.
Talking about count 3 now, not count 2.
That's right. There's a variety of cases that say that even controversies.
Do you interpret count 2 as not asking for a declaration on indemnity? That seems what you just said a second ago.
No, we're asking for a declaration of JMA's rights under the Zurich policy as an additional insured.
Right, specifically those rights are the rights to defend and the right to indemnify. But you just said to Justice Englander that count 2 doesn't have indemnify.
Yeah, because I had it wrong.
I'm lost on the questions. I'm sorry, Your Honor.
He's asking, okay, go ahead, sorry.
Count 2, you're asking for a declaration of their duty to defend and indemnify, right? And
That's
same thing on
correct.
count 3.
That's
okay,
correct.
I'm sorry. It seemed like you said something else. I may have misheard you.
No. And just to get back to the AI argument, Your Honor, it's improper as a matter of law to impose any negligence attributable to Spillane vicariously to JMA. So that's the other reason why the court should have decided the AI argument. So,
Can I ask you this?
certainly.
So in July 2020, Zurich agrees they have a duty to defend. There's no reservation yet. And they say that Engelbert and Bratcher will assume the defense. And then that doesn't happen. Now, I understand once they put in the reservation, you got the right to your own counsel. What happens between July and September? Why doesn't Engelbert ever appear in this? Well, why doesn't it appear in this case for you?
A very perceptive question, Your Honor. The reason why they don't appear is I know Mr. Bratcher well. He's an excellent attorney, but he's in-house for Zurich. So that also would end up being litigated if this case was not dismissed, because that was like a swerve, like for lack of a better term, because they're saying you have your right to your own counsel, but we're assigning our in-house counsel, yet they don't identify them as in-house counsel.
So you refused?
Oh, yes, yes.
Okay.
What about the issue of recoupment?
The issue of recoupment, Your Honor,
Is that live? Do we have to address it? The availability of recoupment under the circumstances?
I think the Superior Court could use some direction on that, Your Honor, quite frankly. And I think that's one of the reasons why we're here. The Massachusetts case law as it stands now is not specifically clear on that specific issue. What is clear is that when you have a
Geez, I thought that opinion by Judge Gantz was pretty clear that you cited and quoted in your opinion, in your brief.
At the time, I was referring to the arguments that I was making in the Superior Court. I'm not going to obviously contradict Judge Gantz, but on a larger...
Oh, no, I say it's pretty clear. I think it helps you.
I agree. If I could just wrap up in the last 10 seconds.
We have a couple of questions.
Okay.
I got two more questions. One, are you asking us to declare or just send it back to the judge and say you got to develop this more? Just on 2 and 3. I'm not talking about 1 and 4 here.
I would rely upon my previous answer, Your Honor, because I honestly think that the court needs some direction on this. Assuming it gets back to the same judge, I don't know whether it will or not, but it needs some direction as to why the dismissal was improper, why it was premature, why the court should have addressed the declaratory judgment issues that JMA brought, and why it shouldn't have been dismissed because it's a declaratory judgment action. It was not premature because JMA has a right to know how this is going to work out when it attempts to resolve the underlying personal injury case.
And my other question is just, is Zurich continuing to pay your defense costs
they are.
In a non-insanely untimely manner?
Well, they have paid the defense costs. There's been some discussion with regard to whether or not our bills have to be submitted through their third-party vendor. We pushed back momentarily. We have submitted them now.
Big picture.
Yeah. We have.
More or less.
The answer is yes, not as efficiently as we would prefer. Thank you.
Thank you very much.
Good morning, Your Honors. Lincoln Rose.
Afternoon.
Oh, sorry. Good afternoon, Your Honors. Lincoln Rose on behalf of the defendant appellee, Zurich American Insurance Company. Your Honors, I'll cut right to the chase. With regard to the Superior Court's decision on the motion to dismiss, at most it was harmless error for the court not to convert it into a motion for summary judgment. Under Rule 12b, when matters outside the pleadings are presented, all parties should be given the reasonable opportunity to present all material pertinent to such a motion.
Wouldn't there still be an issue of attorney's fees for having to file the complaint?
No, Your Honor. The Gamache exception to the American rule, which allows insureds to recover their attorney's fees for establishing, is only applicable when the insured establishes the duty to defend. And here, Zurich, from the onset, initially accepted the defense without a reservation, and then withdrew that and defended with a reservation. But this is not a situation where, say, Zurich denied coverage and Moriarty
I don't understand that answer, and let me tell you why. Because they asked you to pay for their lawyers in July of 2020, and you didn't pay for 8 months, and so they sued you. and they were entitled to have you pay for their lawyer. Even you agree they were entitled to have you pay for their lawyer. So why isn't the legal fees that it cost them to sue you, to get you to pay, why isn't that a breach of contract claim?
Because under Herbert, the First Circuit case, Your Honor, Herbert H. Landy, the court there, again, has said that the gamache gamache exception is only.
I don't know what you mean by the gamache exception. To me, this is the simplest thing in the world. You have a contractual obligation to pay for the lawyer. They send you a bill and you don't do it. They sue you because you breached the contract. You didn't pay. Why isn't that a claim?
Again, when I'm referring to gamache, Your Honor, I'm referring to the case of Preferred Mutual Insurance Company versus Gamache, 426 Mass 93. And there, the court stated that an insured is entitled to their attorney's fees in a coverage action when they establish the insurer's duty to defend. So, for instance, if, let's say, Zurich was in a denial posture.
Okay.
Right, if you'd said, we don't have to defend you, and they sued you and won, you'd have to pay their attorney's fees.
Correct.
But you're saying that if you say, we do have to defend you, but we won't pay for it, we have the duty, but we're not going to do it, then they don't get attorney's fees suing you for it?
Whereas here, Your Honor, where Zurich from the get-go stated that there was a potential for coverage, accepted the defense as an AI, and while the bills were not paid for a time, this was never a case where Zurich denied or said.
Okay, but that doesn't make any sense to me. It really doesn't, and I hope you talk to your client about this. If your client thinks they have to pay, and they send you a bill, and you don't pay for 8 months, you're going to get sued because you breached the contract, okay? And not only that, they should get paid for their lawyers to have to sue you because you didn't pay them, because you breached the contract. And nothing else makes sense in that context. I mean, maybe you can articulate it to me, but not through this gamache case, I can tell you that. I mean, your contract says you're supposed to defend. If you agree you're supposed to defend, you should pay when they send you the bill, right?
Right, but we're talking about essentially a billing dispute and not a coverage dispute.
What was the billing dispute? What did you say to them in the 8 months between the time they sent you the bill and the time they sued you?
Your Honor, well, what I meant by it being a billing dispute is that they're claiming that they weren't paid, but this wasn't a situation.
They actually have two different points, right? One point is you didn't pay us timely. The second point is you have a reservation of rights that we think is unlawful. Okay? Two different points. As to the second one, I understand you have an argument. And the argument is, look, arising under means you actually have to be at fault. And here's the Superior Court case that says that, right? Am I reading your briefs correctly on that?
Sorry, could you just repeat that again, Your Honor?
As to the second point,
yes,
okay, which is we have a reservation of rights. We have a lawful reservation of rights. We have the ability to recoup if we're wrong about whether or not, or if you're wrong about asking us to pay. And as to that, it has to do with this language, what does arising under I can't remember the exact language now I have in front, but what does that mean? And you have a Superior Court case that you cite in your briefs that you claim supports your position, which is you don't have to pay unless it's proven that that Spinelli's guy was at fault, right?
Right.
But the first argument is independent of that. It's simply, you should pay us because we billed you.
And, Your Honor, and they were paid, but what I was getting at is that typically, say that this was not a coverage case, as you know, under the American rule, each party pays their own fees. In a coverage case such as this or another case, the insured is entitled to their fees when they establish the duty to defend. And my point was that we are all in agreement that Zurich has a duty to defend presently and had it at July. So this is not a case where, as I mentioned earlier, Zurich had wrongfully denied coverage or, say, accepted it with a reservation and filed its own declaratory judgment seeking a declaration as to no coverage. The parties have been in agreement that there is a duty to defend, and under the Herbert H. Landy case, Your Honor, the court has stated there that when the insured doesn't establish the duty to defend, they are not entitled to their...
It's not a defense to breach a contract, to say, we agree we're breaching the contract and we're just going to continue to do it. That's not a defense. That seems to me to be what your argument is. That's not a defense. And if, part of the reason that I have experience with this, insurers can't do this. They can't just sit on the money when they agree that they owe it.
At a minimum, why wouldn't they be entitled to a DJ that you have a duty to defend?
Because that point is moot, Your Honor, where at the time, where the bills have been, where the defense costs in the underlying construction accident case have been paid, we are defending pursuant to a reservation of rights, so there's no active or live controversy.
Getting back to that issue, why isn't the uncertainty and its practical ramifications for their self-insured reserve, whatever it's called, enough to give them an interest in having that issue resolved? That you have a duty to defend, which is broader than the duty to indemnify, and here's what it is, and you don't get to then hold this reservation of rights over them.
Well, Your Honor, as other Massachusetts courts have acknowledged, such as Southwest versus the Arbella Mutual Insurance Company, an insurer's action of reserving its rights there's nothing inherently actionable about it, and so there's no, as my brother acknowledged, the issue of Moriarty setting the reserves was not in the record, so there is no actual live controversies where they are essentially getting what they asked for in the sense that they have a defense, and we have acknowledged that defense, so the parties are in agreement as to that. And as Your Honors pointed out earlier, with regards to the duty to indemnify, it is not ripe for adjudication at this time where liability in the underlying matter has not been established at this point.
Can you walk me through recoupment? Could you walk me through the factual scenario that could happen that would allow you to recoup the defense costs?
Your Honor, the factual scenario would be, for instance, if, let's say that it's determined that PJ Spillane, this didn't arise out of their operations, and that it was all Triple G Scaffold's fault, and that Mr. LaHussier's injuries were not did not arise out of PJ Spillane's operations. Therefore, under the AI endorsement, they would not be entitled to AI coverage, and we would have expended fees that essentially they would not be entitled to. I would note there.
But the defense.
Well, hold on. Before we tear it apart, that's what. So if it winds up being not Spillane's at all fault, being all Triple G's, you feel you'd be able to ask for recoupment. That'd be the factual pattern.
No, Your Honor. There was more to it than that, including, for instance, between the time of the briefing, Your Honor, and actually very recently, a case came out of the Federal District Court which found an insurer was entitled to recoupment, Berkeley National Insurance Company versus Granite Telecommunications. And there the court found that there has to be, I think the wording they used was a flavor of extortion. So there has to be a very specific set of facts and
circumstances. Where's your possibility of showing a flavor of extortion? What's the factual thing that would happen that would let you do that?
Again, Your Honor, I'd have to think it through, but again, this was only reserved to the extent allowed by law, and no recoupment has been attempted, and it may not be because, again, this is a hypothetical.
But to reserve a right to recoup, doesn't there need to be some scenario where you could get to recoup?
Right, and that Berkeley case, set forth a very specific example.
No, I'm not questioning, at least right now, whether it's, theoretically possible, but of course it has to be possible in this case for you to make this claim. And you say, okay, so I could see it's possible Triple G could be found to be totally at fault, and what else could factually turn up that would allow you to ask for recoupment? Because you're saying that's not enough.
Right, just the fact that, and I think courts have previously stated that just the fact that it's that you've picked up the defense for an uncovered claim is not enough because the duty to defend is broad. But again, if there was, say, like as the Berkeley court found, a flavor of extortion.
Is there any possibility of flavor of extortion in this case?
You're off the cuff. I'm not Possibly. I don't, there would have to be, some facts, for instance, in that case that the insured was, I recognize that this was not in the briefing or on the record, but, in that case, the insured was pushing hard for a defense indemnification for an entirely uncovered claim and essentially forced the insurer there to either A, pick up the defense or indemnification or be sued. So
The question is with respect to this case.
Right. So I was
With respect to this case,
with respect to this.
is there anything in the record that suggests that extortion or a flavor of extortion is present with them saying, hey, defend us because we're covered under the policy, and the policy says that you protect liability arising out of your, meaning P. Jacob Spillane's, ongoing operations for the insured?
Perhaps if the facts were developed that they knew that this was because of Triple G and not because of P.J. Spillane, and they knew of that fact, but nevertheless demanded coverage, possibly. But again, I think the important point here is that no recoupment has been attempted, and the key language in Zurich's reservation of rights was, if allowed by law. And as my brother acknowledged, Massachusetts case law is murky at best as to whether an insurer is entitled to recoupment.
All of this fell apart when Triple G filed their cross-claim. And then, as I understand this, they withdrew it several months later.
Correct.
No idea why, but that's gone. Is that somehow lurking in the background now? Or what changed in Zurich's thinking from the beginning of this case when they were willing to defend without reservation to where we are today?
When you look at the reservation of rights, Your Honor, it sets forth the basis for that reservation in the sense that you have the AI endorsement, which contains the specific language that a Moriarty is an AI for instance arising out of P.J. Spillane's operations, and it also sets forth the facts there that in the underlying complaint it alleges that the plaintiff's injuries were due to Triple G removing the grate that should have been covering the hole. So that's right there is the basis for the reservation, and as we set forth with the Suffolk construction case is a entirely appropriate basis for that reservation of rights.
Can I ask you one more question about the recoupment? How would that work mechanically? Let's say you figure out there's been flavor of extortion and it's all Triple G's fault. Then how do you get recoupment?
Your Honor, it would have to be through a subsequent case for equitable restitution.
So you'd file a separate case?
Yes, Your Honor.
I mean, assuming they didn't just hand it over to you, which I think is a safe assumption.
I don't think, we'll be receiving a check freely. Are there any other questions?
The question of law, what that language means, arising?
Yes, Your Honor. Insurance contracts like any...
Arising out of your ongoing operations for that insured.
Yes, Your Honor.
The position is that that language would not encompass what's in the complaint, which is P.J. Spillane's employee doing work on the job site that's alleged that he was going up the scaffolding in order to check whether it was properly weighted or counterweighted, fell through a hole. Can we decide as a matter of law on this record whether that is covered or not?
I see I'm out of time, Your Honor. Just
all right.
You may answer the question.
When you say that's enough as a matter of law, do you mean regarding as that Moriarty is an additional insured?
No, I mean whether or not, as the complaint is, as the facts are alleged in the complaint, whether or not you have to cover that.
Regarding the duty to indemnify, then.
What does arising out of your ongoing operations for the insured? It's a question of law. What that
Yes,
means,
Your Honor,
right?
because contract interpretation such as an insurance policy is a question of law, including the language in that AI additional insured endorsement.
And you've cited one case, which is a Superior Court decision that suggests, according to you, that that language is not as broad as I read it, but that language means that the sub's employee must be at fault in some way?
Your Honor,
does not arise out of the sub's ongoing operations unless the sub is in some way at fault.
Your Honor, what that case stands for is a proposition that mere presence at the job site is not enough to trigger additional insured liability. So considering the facts here, which are substantially similar, Zurich reserved its rights in case the facts play out in such a way such as that, where just his injury was just the result of his mere presence.
We have one more question.
Just quickly, you mentioned a case that came out after the briefing.
Yes.
And I didn't get a citation.
I'm sorry, Your Honor. The Westlaw citation is 2022 WL 302-1107.
302-1107.
Yes, Your Honor.
All right, thank you.
I don't have any more questions, but I want to say one thing, which is there are interesting, if confusing, issues here, and we will do our job in resolving them. I have to ask, and this is not a question for you to respond to, it's rhetorical. We often see cases where we say to ourselves, why are we here? And this, for me, is one of those cases where there seems to be a lot of money being spent fighting over stuff that could be resolved. So as we do our job, resolving the legal issues you presented to us, feel free to continue talking to each other to try to resolve this in a way that might make more sense. Because once we rule, at least one of you, and quite possibly both of you, are going to be very unhappy. I'm off my soapbox. Thank you both very much. The case is submitted
to you.
Our next and final case of the day is a DCF matter, 2022 P392. We remind the parties, all being experienced counsel in this area, no, we should not refer to any names. Obviously, you can refer to names of third-party witnesses, but no names of the parties and child. Counsel.
Good afternoon. If it please the court, my name is Christine Bernardi, and I'm counsel for the appellant mother in this matter. Mother is requesting that this court remand this case to the juvenile court for a new trial for two reasons. One is that she was denied due process of effective assistance of counsel in the lower court, as well as there was no nexus between the court's determination that mother had mental health concerns and her ability to parent her child. The juvenile court presiding judge failed to ensure there were safeguards in place for the trial, those safeguards that should have occurred during a virtual hearing or virtual trial. Mother was not informed of any safeguards during a virtual trial, nor were any permitted or offered during the trial. Mother's counsel filed a motion for an in-person hearing on October 6, 2020. That hearing the trial was scheduled for October 20th. I think it was first October 19th, and then it went forward on October 21st. At the first moment of the hearing, the transcript reflects that the judge denied the mother's motion for in-person trial at the start of the hearing, then offered to the mother's attorney the ability to object on the record, which she did. Then he went forward with trial. Now, this case had begun previously in February of 2020, prior to the pandemic. This is a pandemic case in the early phases of the pandemic. The first 2 days of trial went in person prior to the pandemic. The next 2 days that were supposed to occur were in March of 2020. The governor of Massachusetts declared an emergency due to the COVID-19 pandemic on or about March 13th of 2020. And the second 2 days of trial did not go forward because of the pandemic. Courts were closed, the Commonwealth was closed. So we come to October of 2020, and this is the first phase of trials occurring after the pandemic had been declared. Courts were allowed to do in person, they were allowed to do virtual trials or virtual platform trials, in this case a Zoom. However, there were no protocols or standards or anything laid out by the Supreme Judicial Court or by the rules of any of the courts as to how this was to happen if it were to be a virtual trial. So judges were kind of on their own, and so were counsel. These were brand new platforms for all of us at the time, and I've done a number of trials both in person and
As I understand
virtual.
the record, correct me if I'm
Yes.
wrong, as I understand the record, the judge said in response to the objection, we'll make available the opportunity for you to talk to your client, or I think actually, yeah, we'll make available the opportunity for you to talk to your client. And then your opponents say, never asked for it. What do you say to that?
I say that the judge didn't say that in the courtroom, Your Honor, or in the virtual courtroom on the first day of trial. If you look at the transcript, it clearly...
Well, he didn't need to say it on the first day of trial, because the first day of
Oh, the
trial,
first
they
day
were
of-
in person.
Virtual trial.
Okay, so the first day of virtual trial, there's an objection. We want to do this in person. And the judge didn't say, I'll make available...
No.
Well, okay.
No, he did not.
Did it the second day?
No, he did not. What he did was, okay, mother's counsel filed a motion for an in-person trial. That motion was decided in the courtroom on the first day of the virtual trial. The first day of the virtual trial, the judge said, your motion for in-person trial is denied. You can put your objection on the record. She put the objection on the record, the counsel for the mother, and then he told the department to begin their case. There was nothing...
Continue their case.
Pardon?
Continue their case.
No, he didn't continue the case.
No, the case was already going on.
Yes,
The case didn't start
continued
then.
yes,
And the only thing that happens on October 21st is the mother testifies.
yes.
It's not like you get asked a question, you get to confer with your lawyer. You got to keep answering your question. So where was the need, where was the even possible need for a breakout room on that first day? Not the first day, sorry. Making the same confusion. October 21st.
There was a possible need? Well,
Yeah.
we don't know, because mother could have raised her hand if she was told that she could raise her hand, that she wanted to confer with her attorney. That can happen at any time, or she could say, I need a break.
Now
She
you
was-
want us to overturn the result of the case based on some hypothetical. There's no offer of proof. There's nothing.
I'm not asking you to overturn the result of the case. I'm asking you to remand it back for a new trial because her due
Vacate the
process
judgment.
right.
That sounds to me like overturning the result. But in any event, I think that's perhaps just a quibble. The concern I have is you're hypothecating what might have happened, but we don't have any indication that it did, right? We have nothing in the record that says, for example, the mother was being asked about things that the mother didn't want to answer, and had her lawyer been in the room, she wouldn't have had to answer it because an appropriate objection could have been raised. There's nothing like that, is there?
No, Your Honor, but the issue is here is a right to due process. And it's a right to due process through the meaningful consultation and effective assistance of counsel. And that is a structural error. And here...
But how was she denied meaningful consultation in this case?
So let's talk about what happens in a trial. Let's talk about that when you're in person in a courtroom like we are now. Generally speaking, my client is sitting at my elbow, okay?
But not when she's testifying.
Not when she's testifying, but before she testifies.
She's up on the stand
Yes.
and is not conferring with you any differently than would be on Zoom, which is through your objections.
But there's a whole different, it's a whole different atmosphere her being on her telephone in a vehicle or in her home or wherever she is at the time, participating in this trial, and the actual being next to your attorney at the start of trial so you can confer, and then taking the witness stand and being in the same room. These are very anxiety-provoking. Number one, being in a courtroom, being here. I've been doing this for a really long time. And this is anxiety-provoking for me, to be standing here and answering your questions. Now, imagine my client who has anxiety, she's diagnosed with anxiety, and she doesn't have the comfort.
This is a general argument that we should not do Zoom-based trials, and I think the SJC has rejected that argument.
I'm not saying that, but the focus here is on my client's right, not a Zoom-based trial. I mean, I know what the SJC has said in Vasquez and Diaz and in Patty. I know what they've said, but each case needs to be looked at as an individual case if a client's rights have been violated or her due process rights have not been granted. And that's what I'm suggesting.
I couldn't agree with you more, that there's a huge difference between Zoom and being someplace in person. The concern that I think you're hearing from more than one of us is, what are the facts here, given that she's on the stand? What does the record tell us about how her rights were really impaired?
Well, if the judge had informed her, if he had informed her that if she needed to consult with her client, with her attorney during the course of the trial, that she could raise her hand and she could do that, she might have done that, Your Honor, but she was not informed of that. She was not informed that there was actually, I'm not even sure, because this was the first phase of the implementation of
Did she know she could do that in the 2 in-person days?
I'm sorry?
Did she know she could do that in the 2 in-person days? Did anyone tell her before the February 3rd and the February 5th day that on your stand, you can raise your hand and say, I want to consult with my lawyer at any time?
I'm not sure.
I'm pretty sure it wasn't done.
It wasn't done.
I don't understand why this is
in terms of the
different
transcript,
in
Your
person
Honor.
versus Zoom. Someone gets up on the stand, no one tells them in the middle of your testimony you can consult with your lawyer, and they're not standing next to the lawyer anymore. So why is that different on Zoom than in person? You seem to be suggesting that unless a witness is told that live or Zoom, that it's a violation of due process.
Because in a set of circumstances where you're in the courtroom with your client and your client's in the courtroom with you, and there are different, you can see what's happening with your client. You can see, I could say, Judge, may I have a brief recess because I see my client
You could do that on Zoom too. You actually get to see them face,
You can,
face
but you
close
can't,
up.
you can see, well, it depends on the angle of the camera, it depends on how good the lens is, it depends on a whole lot of things when you're talking about Zoom. There's body language that does not come through on a screen, on a phone screen or on a computer. You're looking at Hollywood squares. So sometimes, if I'm looking, and I would say this when I was doing Zoom arguments with the appeals court, I'm looking at the 3 judges' faces, but I was exhausted and had a headache afterwards because I'm trying to
Because you were looking
figure
at
out,
us. Who can blame you?
but I was trying to figure out how you were like right now I can look at you pretty easily, but when you're on a screen, it's like.
Counsel, I think we understand that. I
Yes.
want to make sure you have time to address your other arguments.
In terms of my second argument, Your Honor, is that in this case, it is clear that the judge found that mother had mental health concerns. But the question is whether or not those mental health concerns, there was a nexus between those mental health concerns and her ability to care for her son.
Isn't at some point the nexus self-evident? This is a case where the mother was diagnosed with many different serious mental health issues. She was exhibiting psychotic behavior, and she was making active threats to, quote, kill a few people. What does DCF need to show to prove that this is a nexus to her abilities to parent the child?
Okay. The answer to that question is people say a lot of things. Okay, people, when they're angry and they're upset, they say a lot of things. And I'm sure that you've heard different people say, I'm going to kill them, when they didn't really mean they were going to kill them. They were just angry. Can start with that. The various diagnoses were at short time frames that they were not long existing diagnoses where she had met with a psychiatrist for a long period of time, and those diagnoses came about. They were short-term stays where they were working diagnoses. Moving on from that, however, mother did have the care of her child from his birth until his birth was in July 26 of 2018, until May of 2019, with a couple of brief times where he was removed.
He was removed because she was hospitalized.
He was removed because she was ordered by a court to be evaluated to determine if she was competent to stand trial. They were criminal cases.
How many times during the period that she was caring for the child, which is, I think, the first year and a half of the child's life, roughly, right? Till May of 2019?
Mhm.
How many times was she unavailable due to either mental health or incarceration?
2 times.
So were those both mental health, or was there an incarceration?
They were both orders by a trial court for her to be evaluated for competency to stand trial. So they were not within, there was an order of the court. She had no option but to go. And each time, she was found competent and released.
After weeks, in one
Well,
instance.
that's the length of time that the trial court keeps a person in Worcester Recovery Center of the Solomon County Fuller for evaluation. There's not an option, that's the length of
Your
time.
suggestion that because she was ultimately determined to be competent after weeks, that's not a relevant consideration? The fact that she apparently is in and out of situations where she literally is unable to care for the child because she's hospitalized?
You could compare that to someone with chemotherapy who has hospitalizations for that, but she had her mother. She was living with her mother at the time, and her mother was available to take care of the child when she was not. And the department says that in their assessment, which is in the exhibits. And during the time, and there were no questions ever in regards to mother being able to take care of the child while the mother was present. Also, during the course, many professionals who had seen mother with the child said that he was well cared for, that he was up to date medically, that she was following through with all of his needs.
I couldn't figure this out from the record because it seemed to be inconsistent in the briefs. Was she incarcerated during the period since he was born?
No. Not that I
thought that she was, I don't know, I must have misread something. I thought that she was,
No,
she was on probation, and I thought the probation was revoked because when she was on probation, she violated, and that she wound up serving 90 days. But I perhaps misread that.
Not to my recollection, Your Honor.
Thank you.
So, Your Honor, I'm asking this court to remand this matter for a new trial so that for mother to have a fair and a trial with due process and fair and
Just one last question from me. Her rights were not terminated.
No, they were not.
So she gets review and redetermination, et cetera. How is that in practical terms different from the remand you're seeking?
Your Honor, because she's been found unfit. So a fitness finding.
I wasn't presuming the answer to that question. That was a
The
real
fitness
question.
finding itself is detrimental to her in a second trial. So she goes in for a right to review and redetermination, and they still look back at the previous history and the unfitness and the determination of unfitness. So that being the case, you come back, like that impairs her in a right to review and redetermination as opposed to a new trial.
So I do have a question that I fully expected my brother to ask, which is...
I was going to ask that.
Go
later.
ahead, you do.
I was going to ask that later.
Not to her.
Different counsel. You want?
Well, I think we should ask.
Okay. So it seems to me that if father files a paternity suit under 209C, Section 10, then it won't make any difference whatsoever whether your client is unfit. It'll just be a question of best interest. That's what the statute says.
I disagree. And the reason I disagree is because the findings of the juvenile court will be used.
Oh, no,
in the
I
209C
don't question
hearing.
these findings would be bad in such a thing. But even if we reversed, why wouldn't there just be a 209C action where it wouldn't really matter whether there was fitness, it would just matter what was the best interest of the child?
And that would be a wonderful you remand down for a new trial, he files a 209C, and then there would be fair playing ground where, mother was not found unfit. All of the issues would be tried in the probate court. I would see no problem with that, and that's what I would expect to happen if this were to be remanded.
To put a finer point on it, though, why did there have to be a fitness determination for DCF to decide to give the child to the father here?
Because under 119, Section 26, there needs to be a determination. The father was not, the case was brought against mother, not father. And therefore, mother's fitness was the fitness that was in question at the time.
Okay, thank you.
Thank you.
Thank you, counsel. We'll hear, I believe, first from the department.
Good afternoon, Lynn Murphy for the Department of Children and Families. The issue before you today is whether the trial court properly found mother unfit and granted father permanent custody of his son. I think the evidence and the trial court's findings overwhelmingly established mother's ongoing unfitness. She had a lengthy history of mental illness, instability. She was hospitalized 3 times during the pendency of the care and protection. Her testimony at trial showed she continued to be unstable and had not made any progress despite a tremendous amount of services, not only from the department, but the Department of Mental Health, and also as part of her probation, I think it was the Franklin County services also put therapy in place. None of these services resulted in
Let me ask
change.
you, this is going to take you off your trajectory, but let's say we affirm permanent custody of the biological father, then what happens?
What happens?
What happens next? Is there more court proceedings? Does someone have to raise their hand and say, I want it changed? What happens? Are there automatic reviews?
You mean what would the department do next? Or
What would anyone do? I mean, I really was puzzled by, because usually it's not given to the biological father. Usually the child's given to foster parents. And I know what happens then. There's an adoption.
I wouldn't say it's usually.
I mean, the cases we see. We only see the
right.
a very small sliver. But
The department always works to place children with family. If there's a parent, that's a priority. And that is what happened here. And as you saw with the oldest child, that child also lives with the father. So
normally the department, if there's no termination, keeps providing services, hoping to make the parent fit again. Do they do that in a situation where the child's been permanently placed with the biological father?
Well, this is outside the record, but this woman continues to get services from us because there are 2 other children that had been born and were
it's in the
also
record.
removed. So the department is still very actively involved in this case with this mom. But as far as, the C&P would probably be off-listed at this point, and whether the department would dismiss it. I mean, there's many options that could go forward. I can't really speculate as to clinically where that would fall.
So if it dismissed the C&P, the mother would lose her rights to review and redetermination, but presumably she has probate court rights, correct?
That's right. So there are other avenues for mother. She could certainly come back on a review and redetermination. And
Not if you dismiss the...
Not if we dismiss, but then also mother, I mean, it's hard to speculate. The department doesn't always seek to dismiss its care and protection petition. And whether it would do so in this case, again, I don't know, because there is ongoing services being provided with the other 2 children. So, but there's at least 2 avenues it could go. You could go back, we off-list the C&P, mom could come back. If nobody wanted to do that.
Is there any light you can shed on the questions from my colleagues in terms of how we stayed in this posture as opposed to it getting pushed into a 209C?
Well, I think what happens, and again, this was a client that we had worked with for many years. So at this point, the department has to prove the merits of its case. It's filed a C&P. It has overwhelming evidence of unfitness, and it goes forward in that vein.
I take it, because I'm the neophyte in this crowd, that the C&P requires a determination of unfitness?
That's correct. That's
Okay.
right.
That's the statutory
That's the
requirement.
merits, right. The department has to show meet the merits of its petition, which it did so in this case.
Child is in need of care and protection, requires a determination of the mother's unfitness.
Right, exactly, which was done so here. So that's, and it is, by the time I got to trial, and this had gone on for 3 or more years, right, at that point, and then father had custody for a very long time at that point. So it did seem like, oh, maybe.
It's just so confusing to us because the child doesn't need care and protection because the child has a biological father who's fit that they're with.
But not at the time that the care and protection was filed.
No, that's
So
fair.
that is what happened. So then when you get again, the department has to gain custody because of the circumstances with mother. Father was not a custodial parent at that time. And then we work with the father. I mean, you don't see it very often, but it actually does happen fairly frequently because the department endeavors to keep families together. And if we can find a fit father, obviously that would be.
Yeah, and I'm sure it happens all the time, but we never see those ones. This is the first time.
You don't, that's right.
Didn't see that coming, did you?
Even myself, right, in my practice, I don't see all the workings of the clinical side because we only get the litigated pieces. But I see my time has expired. If there are no further questions, I will rest on my brief.
Thank you very much. And for the record, Judge Englander's chuckling had nothing to do with the facts of this case.
Oh, yeah, I apologize if you gave that sense. No.
We will hear next, I believe, from the father.
Good afternoon, Judge Ditkoff, Judge Milkey, and Judge Englander.
No, you got to do them in seniority order. You can't do them.
Pardon me?
You can't do them left to right. You got to do this in seniority order.
We will stipulate that you meant to do it in seniority.
Well, but you see, I'm 74, and if we were going in seniority order, I should have introduced myself first. So, Deborah Sirotkin-Butler, presiding Justice Milkey, Justice Ditkoff, and Justice Englander. I would like to address some questions that I heard that didn't seem to quite get answered, and I come to this argument in a somewhat unusual position in that I have also been a divorce attorney and have 40 years' experience in family law.
And we usually see you on this side of the podium.
Yes, we do. And first off, the references to the lockup for mother are in the record appendix at page 90, page 36, page 100, and page 191. And the lockups were not due to mental health. These are addition to the hospitalizations. They are to repeated OUIs. When she went beyond 3 OUIs, she got 90 days lockup and a breathalyzer. And I would have to go beyond the record to tell you about that now.
That was before this child was born, though, right? That was before this child was born, right?
These were spread over time. Some of these happened during the case after the care and protection was filed. She has an ongoing, long-standing history of self-medication. As the record reflects, when nobody will prescribe Adderall, and I can give you the page sites, she testified, I go get it on the street, and I take enough so I don't have to sleep, so nobody can do anything to me when I'm sleeping. So there are multiple.
And we would find, you've given us the page sites where we would find that.
I have. Again, in terms of lockup, it's discussed in my brief on page 14, and the sites are Appendix 90, Appendix 36, Appendix 100, and 191. There are multiple references.
How many lockups were there while she was, while this C&P was pending, do you know?
How many lockups there have been in total before, during, and after, I do not know. During this one, I believe there was one. That's my read of the record. In all of these cases, it is unusual for the same person to be trial attorney and appellate attorney. I wasn't trial attorney on this case, although I have met with all the parties and remain in touch with trial counsel.
Well, do you have any insight on why your predecessor didn't file a 209C?
Yes, I can describe that. The reason a 209C was not filed is that there was not a cohabiting or longstanding relationship, and my client did not initially know he had a child until after DNA work was done. At that point, the juvenile court was already involved, Justice Englander and Justice Milkey. And what happens is when a probate and family court knows the juvenile court is involved, they say, oh, we can't address it. We won't touch that case. The juvenile court has authority over that child. And the very experienced trial counsel for this very young father said to him, more likely than not, we can try, but they won't touch it. And I can tell you that once the juvenile court is involved, probate and family court justices will not touch the case. I consider best practice is to address it with the Chief Justice of the trial courts and ask for a dual sitting, which I have done 3 times. And what one does in such a case is one requests that a trial judge sit as both the judge of the probate and family court and the juvenile court. But otherwise, juvenile courts are very different. Everything is impounded. They are not criminal, but they are quasi-criminal. And once a juvenile court has a child's case, the probate and family court has a venue issue, a statutory issue, and a structural issue. And the only way to address that is to have a judge sit in both courts. And the only way to get that to happen is to go through the administrative process with the Chief Justice. They don't love me, but I do it.
Counsel, unless my colleagues have any further questions, your time has expired. So,
thank you very much.
Good afternoon. May it please the court, Eric Beal on behalf of the child. The child in this matter supports the order of unfitness on placement of permanent custody with the father. The child has lived with the father for over 3 years, since he was just about 1 year old. This has promoted stability for him, which is an important outcome of the trial court's decision here. Related to the due process argument, and just distinguishing Patty from the circumstances here, I submit that mother here had a meaningful opportunity to be heard. She was present every day at trial, the trial of both the virtual and the in-person sittings. The mother testified every day that testimony was heard. And certainly the judge encouraged her and other parties, if they needed a break, orally on the record, but also in his written decision on the motion for in-person trial, that those breaks would be allowed. By contrast, in Patty, the mother was essentially not present for almost the entire trial. The trial judge in Patty found an adverse inference against the mother. And mother was pro se, although there was standby counsel. And again, here, mother was represented by counsel each day and was present. And for those reasons, I submit that.
Could you address the specific argument that there isn't a nexus here between the mother's mental health and her ability to care for the child?
Yes, Your Honor. And mental health is sort of one of mother's issues as found by the trial court that contributed to her unfitness. But certainly the mother's hospitalizations, but also her conduct throughout the course of the trial related to the father of the child in this matter, but also the father of a child in a prior matter, showed that she led what I would characterize as a sort of chaotic existence in being arrested multiple times and being hospitalized multiple times, and that in the interests, really the best interests of the child.
There was no evidence, though, that any of this had an impact on how the child was being cared for, was there?
The judge did find that the mother had promoted a warm and caring relationship, and that was one of the reasons that there was no termination here. I would submit that the record shows clearly that mothers, again, multiple arrests and hospitalizations would have promoted an environment in which she really wasn't able to provide the care that the child needs here, whereas the father, who had stable housing, stable relationships, stable employment, and was available to parent the child, and the record, I think, stands for the proposition that he was doing a good job.
What do you say to your opponent's view of this? I mean, so at some point, you know, we say, yeah, you may be eccentric and you may have problems and you may even wind up with an OUI every once in a while and in the lockup for a couple days, but you're not entitled to a perfect parent, right? And unless it's having some kind of impact on how the child is being brought up, maybe you're not unfit. What do you say to your opponent's statement? Look, this is just like they're going through chemotherapy, which, you know, can take you away from the child for weeks at a time.
Well, in this case, Your Honor, there was evidence that the mother's own therapist, when asked about her parenting ability, I believe by the court-appointed investigator, said, mother can do it physically, but she can't do it mentally. And there was a lot of evidence as to mother's mental instability. I believe that the trial judge was within his discretion to find that that instability rendered her unfit.
And I believe, tell me if I'm wrong, under the order or decree, mother has monthly visitation with the child. Is that correct?
I believe that the trial judge left with the discretion to the custodial parent the nature of the ongoing visitation. There have been, this is outside the record of this trial, there have been other interruptions with mother's ability to visit due to other criminal issues. And that perhaps may explain why, in the large amount of time between the final judgment in this case and now, even though mother is entitled to a review and redetermination trial, none has been requested to this council's knowledge.
I'm confused because I'm looking at the document here and it says mother is entitled to monthly supervised.
Your Honor, you're correct. I was confusing that with the sibling visitation. I see my time is about to expire if there are no further questions.
I think we have it. Thank you all very much. The case is submitted. This concludes our hearing today. Thanks to the court officers and the law clerks and the clerk's office.